about Cook?
Cook is going to be the same thing I'm covering for CAC. I believe that there was bonds set at first appearance as well.
And Mr. Kleins, you seem to be currently assigned to several of these that are related.
Your Honor, these were all transfers from juvenile court. With Mr. Cunningham and Mr. Arnett, we had previously filed a motion to withdraw in juvenile court based on our existing representation of Mr. Almanza. So that's why last week I had notified Mr. Maddox, hey, I don't plan on being at the detention hearing. You know, unaware that Mr. Almanza was going to be, I think he was in the hospital at the time, but I'd let the public defender's office know, hey, if the discussion comes about withdrawals or stuff, we cannot be appointed to Mr. Cunningham or Mr. Arnett, as we already represent somebody involved in this.
You're moving to withdraw. It looks like your motions were filed yesterday on Arnett and Cunningham.
I spoke with my assistant yesterday, and I said, make sure we file them in the circuit court also. But yes, we are moving to withdraw for those two individuals.
Does the PD have one related to that case?
Your Honor, I show that we have Elijah Murray.
All right, so let's bring them out and see how we're going to address this.
You can't have a hearing, so can I let my cop go
On which one?
on all three of the ones that
We're going to go through them pretty quickly, but I just want to make sure that everything's cleared out before you start excusing witnesses.
Yes, Judge.
Who do we have?
Your Honor, this is Marcus Ingram before the court on 26 CF 376.
All right, so Mr. Ingram, you're here on an aggravated battery charge. You were set for a pretrial detention hearing, but you were also given a bond if the state didn't file for one of those. They did not ask for a pretrial detention hearing, so your first appearance bond will go into place. That's a $15,000 cash or professional bond with pretrial supervision where you have to report to them weekly in person and have no contact with the alleged victim, not to be within 500 feet of that victim, the victim's vehicle, victim's residence, or place of employment.
Judge, to perfect the record, the state did file on it. We're just not moving forward with it.
I apologize. You are right about that, Mr. Sprousser. We don't usually have 6 or 7 of these like we do today. So you can post that bond if you'd like. Ultimately, your case will be in my division once you've had a chance to meet with your public defender. I'm not sure if that's going to be you, Ms. Rivers. It's
Mr. Williams.
will be Mr. Williams. They can set a bond hearing if you can't make that bond, and I'll entertain it at that time. All right. Thank you, Mr. Ingram. Yeah.
Okay.
Just verify he's got bonds on both. This is Sean Cook. He's here in 26 CF 374, where he's arrested for lewd and lascivious molestation, felony battery and obstruction without violence. And then in the 26 CF 375, it's the same one. Felony battery and resisting. Is the state going forward on those?
At this point, I believe so.
I don't see that you filed a motion.
Oh.
On Mr., I'm sorry, on
I thought you were asking if we're going forward on the charges. No, we're not moving forward on the pretrial detention.
pretrial
for Mr.
detention.
Cook.
I'm sorry. When I said those, I meant those cases. So my fault for the miscommunication. All right, since the state's not going forward on those, your first appearance bonds will be put into place. trying to figure out because they've got kind of the paperwork all mixed in together.
If you bond out, you just call.
All right. So, Mr. Cook, at first appearance, that judge set your bonds at $100,000 cash or professional on the L&L charge, $10,000 on the felony battery, and $15,000 on the obstruction or resisting without violence. If there are any other conditions. Weekly check-ins with pretrial services, a GPS monitor at $1 per day. You're to vacate the residence where you're residing with the alleged victim, no contact with that victim, the victim's vehicle, victim's residence or place of employment, don't go within 500 feet. You can go back once to the residence with law enforcement to recover your personal items. No unsupervised contact with any minors, and do not be where minors congregate. Thank you. All right. You want to bring up Almanza first, Mr. Kleins?
Your Honor, is the court intending to hold 3 separate detention hearings on the same set of facts? I don't.
Wouldn't be a pretrial detention hearings. Well, I think the intent was to get them all here at the same time and have one hearing. But since 2 of them no longer don't have assigned lawyers, I'm not sure how I can do that.
Okay, I wasn't sure when you were like, we'll just bring out one individual. I was like, okay, like,
It's my understanding that Mr. Almanza, your client, was just arrested a couple of days ago.
he was in the hospital. He'd been, yes, there was mental health issues. So he was recently just arrested. I don't really have, I'll defer to the state, how the state wants, it's their hearing, so.
The state is ready to proceed. I mean, we have our witness. I
Okay.
understand we don't want to have the same hearing over and over again, but Mr. Alonso has rights.
Okay.
If the court wants to proceed, I'll go ahead and we can do Mr. Almanza.
Okay, that's fine.
Yes.
I mean, there's judicial economy and there's doing things in violation of people's rights because I want to make it easier. I'm not going to do that, obviously. So we'll have a hearing from Mr. Almanza today, and then we'll bring the other 2 out afterwards to assign them new lawyers. Did you send over orders on that, or your office, Mr. Kleins, do you know?
The orders should have been submitted. I'll confirm with my assistant. Typically, when we file those motions to withdraw, the orders go hand in hand.
Don't have one. All right, Mr. Kleins, I don't have an order on Arnett's case.
I will, as soon as I'm done with this hearing with Mr. Almanza, I will text my assistant and have her get that.
Just so I can get their new lawyer assigned also.
Absolutely. No, I understand.
I signed the one on Cunningham already. It's put some already notes on that case, so can you give me, Williams, I guess, would be next. I can put on Arnett's case, just so I can tell the people who they're gonna have.
May I approach on an unrelated matter, just briefly?
All right. Just to make it clear, we're back to Rudy Almanza, 26 CF 319, pretrial detention hearing on a charge of home invasion with robbery with a firearm.
May it please the court?
Yes.
Cody Sprouse on behalf of the state of Florida in case number 26CF39, the state would call Investigator Rodriguez, if he is here.
Is this your only witness?
It
Mr.
is.
Press? Okay. All right, can you raise your right hand to be sworn? Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, take your seat, please. Please speak into the microphone so we can all hear you.
Good afternoon, sir. How are you today?
Good, sir.
Can you please say your full name and spell it for the record?
Ivan Rodriguez, last name Rodriguez.
What's your occupation?
Investigations with the Crestview Police Department.
How long have you been with Crestview Police Department?
Just over 3 years.
How long have you been an investigator?
I believe over 2 years.
Did you have any prior law experience before you joined CPD?
Negative, sir. I was military.
Okay. How long were you in the military?
22 years active duty.
All right, thank you for your service.
Thank you.
On January 18th, 2026, did you conduct an investigation involving Rudy Almanza?
Yes, sir.
What did your investigation reveal?
So my investigation revealed, based on testimony statements, suspect statements, Rudy coordinated to meet with Mr. Odom.
And
he
who's
was-
Mr. Odom?
Mr. Odom is the male victim in this case.
Okay.
So he was the only one in phone conversation and knew where Mr. Odom was staying, which was at the hotel.
Okay. And what were they supposed to meet?
They were supposed to meet to smoke marijuana.
Okay. At the hotel?
Yes, sir.
Around what time did this occur?
I don't remember off the top of my head. It's in
Was
my
it
report.
evening time or?
Yes, sir. It was evening. I believe around 2200, 2230, 10:30 at night.
And you said the hotel. What hotel is that?
Again, that's in my report. I believe they changed the name recently. This was at the location of 3925 South Ferdon Boulevard.
Is that the Quality Inn?
Yes, sir.
Did they ever meet up?
Yes, sir.
All right. What happened when they met up?
When they met up, Elijah and Rudy Almanza were the first to speak with Mr. Odom.
And is Elijah a co-defendant?
Yes, sir.
Continue.
And the two victims were familiar with Elijah Murray and Rudy Almanza. Mr. Odom stated that when he handed him some marijuana, he was then struck by, he said all he saw was a black hand strike his face.
Did Rudy strike him?
No, sir.
Okay. So are Elijah Murray and Rudy Almanza inside the hotel at this time?
There were conflicting statements. I was told that they were standing at the entrance when other masked individuals entered the hotel. And then at another time, they stated that they left and then immediately came back in wearing masks.
Did these masked individuals arrive with Mr. Alonza and Murray?
Yes, sir.
And how do you know that?
Based on their statements, Mr. Elijah Murray coordinated a ride, which was captured on flock cameras from his 16-year-old cousin, Monica. And you can see her vehicle drive to the area during the time of the incident.
Okay. So what happened inside of the hotel?
So in the hotel, Mr. Alonzo, he didn't want any part of it, is what he stated. And based on the victim's statements,
Any part of what? I'm sorry. What happened?
so he was aware that the two other co-defendants from Fort Walton intended on robbing the victims.
Who were those co-defendants?
One is, I think it was Demontriel Cunningham, and the other is Carson.
Carson Arnett?
Yes, sir, Carson Arnett.
So did Rudy Almanza tell you that he knew that they were going to rob Mr. Odom?
He stated that he heard them talking about it, but to my recollection, he wasn't sure if they were serious or not.
Okay. But he knew that they brought masks to the hotel, correct?
That I don't know.
So once, let's say, all four individuals, are inside the hotel, like, what happens? What's the crime that occurs?
So, what I identified as Mr. Cunningham, he was the individual who struck Mr. Odom. As he was attacking Mr. Odom, Mr. Arnett, went for the female. Both the victims were sprayed with a chemical compound, either mace or pepper spray. The female started to run towards the bathroom to try to get away. I was told that Rudy Almanzo was trying to usher her away from the violence. And do you want to know what happened after that?
So Rudy ushers the female victim into the bathroom. What happens in the bathroom with Mr. Alonzo and the other co-defendant?
So Mr. Arnett, Carson, he gets a female. He was striking her in the back of the head, and he had her like bent over in the bathroom. He grabbed her buttocks and was making sexual gestures.
And what was Rudy doing at this time? Was he present?
According to the victim, yes.
In the other part of the hotel room, what was happening at that time? Excuse me.
The Mr. Cunningham was beating on Mr. Odom. He had him on the bed, was beating him with a pistol. And Mr. Odom stated at one point, Mr. Cunningham put the gun under his chin during the struggle and pulled the trigger, but it didn't go off. And Mr. Odom had a scratch under his chin that could potentially have verified or could potentially verify what he's stating. There's a narrow scratch, like the front side of a pistol.
Okay. Was anything taken from the hotel room by the defendants?
Yes, sir.
What was taken?
So there were Mr. Odom's bag, like backpack, the female Alexis Bryant, I believe is her name, her purse, phone, all their IDs, money, anything that they could grab.
So you learn about this incident at the Quality Inn. Did you make any efforts to locate? Did you learn who these individuals were?
Yes, sir. We were able to figure them out pretty quick, identify them and locate them in less than 4 hours.
And that was because the victims identified two of the defendants?
Yes, that helped out a lot, yes.
And did you know where one of those defendants lived?
I was not familiar with any of them, but the other officers that were on scene were.
So did you end up arriving at the defendant's, Mr. Almanza's residence?
Yes, as I was on the scene, I sent officers to their residence.
Okay. And who was there?
The 4 individuals that were there was Mr. Cunningham, Mr. Almanzo, Mr. Murray, and Carson Arnett.
And did you end up going inside the residence?
I personally did not.
Did any of your officers?
Officers did, and they located a lot of the weapons and or a lot of the tools that were used.
Okay. They located masks?
They located masks. There's a total of 4 masks. 2 masks were located initially, and then there are 2 more masks that were later located.
Any guns located?
One Glock firearm and one, it was a air pistol look-alike.
And was that air pistol taken from the victims?
Based on statements, it was taken from the victims.
Did Mr. Almanza admit to his involvement in this case and setting it up?
Yes. Mr. Almanzo appeared very cooperative.
That's all I have, Judge.
Mr. Kleins?
What specifically did Mr. Almanza tell you about setting this up? Do you recall?
What I recall is him and Mr. Odom speak often and had messaged him earlier in the day that he had wanted some marijuana.
Okay. Have you talked to Officer Vega about this? Was Officer Vega the first officer on the scene?
Yes, sir.
Okay. Now, in your supplement, in part, you wrote that Mr. Odom and Ms. Bryant, quote, reported that a group of unknown male subjects forcibly entered their hotel room. But after hearing your testimony today, is that accurate?
So based on what I personally have experienced with other individuals that experienced a traumatic event, she also stated that she thought there was more individuals, but video footage shows there's only 4.
Okay.
So based on, those were her statements at the time.
Okay, okay. Now, pardon me, I was trying to follow along when you were testifying. Did you testify at some point that Mr. Almanza was wearing a mask or was not? I don't recall.
I cannot confirm whether or not he was due to conflicting statements.
Okay. But it seems to you that only 2 of these 4 individuals had weapons. Is that accurate?
To my understanding, yes, sir.
Okay. And Mr. Almanza was not one of those individuals, correct?
Correct, he was not.
And you had just testified that at one point he had, for lack of a better way of saying it, tried to shepherd Miss Bryant away from the violence, for lack of a better way.
Yes, sir.
Okay. And while Ms. Bryant was in the bathroom of this hotel room is when Mr. Arnett tried to sexually assault her?
Correct.
Do you remember writing in your supplement that Ms. Bryant told you that Mr. Almanza was in the doorway of the bathroom, quote, observing the assault with what appeared to be pity on his face and did not intervene?
Correct. That was her initial statement.
Okay. And at this time, Mr. Almanza is not armed, right?
Correct.
Mr. Arnett is armed, right?
One was armed with mace, the other with a firearm,
Okay.
to my understanding.
Either way, somebody had a firearm, somebody had a chemical weapon, right?
Correct.
Okay. Now, I want to ask you, because I think it's a typo, but correct me if I'm wrong. Further down in your supplement, you wrote, when the home invasion robbery occurred, it was apparent that the defendant did not engage in the robbery. I'm assuming you're talking about Mr. Almanza, right?
Yes, sir.
This is on page 3 of 6.
I think mine's different.
Can I approach the witness, Your Honor, so I can show him? Oh, wait, it's probably right.
This one, this was with a,
So, Reverend Don, I said.
I apologize.
No, that's why I was asking, because I know some.
Here, I'll go ahead and,
Lines, if we could hear too.
I'll go ahead and read it,
Sorry.
what you have.
So investigator, maybe if I just tell you, maybe it might jog your memory of what's been written down here. So when the home invasion robbery occurred, it was apparent the defendant did not engage in the robbery, as both victims recounted the defendant had made overt actions to those offenses. My question is that a typo? It doesn't seem consistent. Like the first half of the sentence is saying he wasn't involved in the robbery, but then the second half of the sentence kind of says he made overt actions. Is it supposed to say he made no overt actions?
Possibly. Based on both the victim's initial accounts, he didn't seem to be very involved other than the meeting.
Okay. And Mr. Almanza appeared remorseful or had remorseful expressions on his face according
Yes,
to
sir.
the victims? Okay.
According to them.
And so I know it's not your decision on what the state charges Mr. Almanza with, but it looks like, according to your report, you believe that Mr. Almanza was an accessory after the fact?
I do.
Okay. I don't have any other questions.
Redirect.
That statement about overt actions, were you trying to say that he was principal to the robbery?
I'm not sure if, I don't see that in here, and I know when I first was working this, there was a lot to it, and I was still building that report.
Okay. So if somebody, well, because Mr. Almanza set up this meeting, that makes him principal, right?
Yes, sir.
Okay, that's all I have.
Take your seat, sir.
Yes, sir.
Any other witnesses or evidence?
No, Your Honor.
No, Your Honor.
Argument, Mr. Sprouse?
Yes, Judge, we are here for a pretrial detention hearing. There's 3 elements that the state has to prove. One, that the defendant is charged with a dangerous crime. Robbery of a dwelling is a dangerous crime under the statute. Second thing that the state has to prove is that there's a substantial probability that the defendant did commit this crime. Given the testimony today, it's clear that but for Mr. Almanza's setting up of this meeting, that this would not have happened. So the third and more difficult prong is saying that there's no condition of bond that will ensure the protection of this community. So, candidly, the state doesn't have any evidence other than the fact that this is a dangerous crime, and that's where we're at.
Mr. Klein's your argument?
Clearly, this is a very bad situation. I think the evidence today, number one, the case is very, very, very young, so to speak. Nobody's really been questioned under oath other than Investigator Rodriguez about what's happened here, you know. And to his credit, I mean, he was candid with the court in saying, look, there were inconsistent statements that we were receiving, you know. I think it's quite an assumption at this point to assume that it can be proven that Mr. Almanza conspired with these individuals. He may have set up a meeting, but at this point, the court hasn't really heard details of how this conspiracy came to be or how the officers believe that there was a conspiracy. I mean, just because somebody knows somebody doesn't necessarily mean that they're conspiring to commit a crime, you know? I mean, anytime ski masks are involved in a criminal event, we're in the deeper end of the pool, you know? Mr. Almanza was not wearing a ski mask. As a matter of fact, it sounds today like Mr. Almanza was trying to minimize some of the violence that was going on in that hotel room. He was trying to move the female into a safer area where Mr. Arnett may or may not have advanced toward her with bad intentions and some kind of a weapon. And Mr. Almanza is standing there feeling bad for her, unarmed, while one person sounds like they're being pistol whipped on a hotel bed and another person is being sprayed with mace and sexually assaulted. So I would submit to the court that Mr. Almanza, who, and these are, as far as I know, they're all juveniles, you know, doesn't know what to do, you know, and I am not conceding his guilt in any way, shape, or form, but if any of this testimony today comes to fruition and this is how it went down, it sounds to me, at worst case scenario, and I understand the concept of principle, and I'm not trying to argue about all of that, but maybe he set something up that wasn't what he planned. And I don't know if that's the case to be. But when we have an investigator saying Mr. Almanza, in his opinion, is an accessory after the fact, well, that's what I think the court should be looking at. I mean, if I represented Mr. Arnett or Mr. Cunningham at this point, I think I'd be done talking right now, you know? But the situation is that the state is trying to hold a juvenile without bond, which the Florida Constitution gives everybody in the state of Florida a constitutional right to bond. I'm not asking the court to set a low bond. I'm not asking the court to set, like, I wouldn't even ask for a signature bond, but I wouldn't even ask the court for a $10,000 bond. I would think in this situation that the court should set a $50,000 cash or professional bond. Mr. Almanza has already been evaluated by Mental Health Pretrial Services. If the court sets a bond, it should place Mr. Almanza on Mental Health Pretrial Services. The reason why my office continues to represent Mr. Almanza is he had a juvenile case pending at the time. So I have not represented Mr. Almanza prior to today. That is another attorney in my office on the south end. I'm assuming there was never issues with failing to appear or anything like that. I don't know. I'm not going to sit here and say for sure that was never a situation. He lives in the area. His mom is present. I don't really know what else I can do. I mean, it sounds to me like of the four that Mr. Almanza is one of the lesser culpable individuals. Again, I'm making all these statements not knowing what everybody's going to testify to. So that's why one of the reasons I don't like these hearings happening so fast is because, as a matter of fact, when I approached the investigator, he was flipping through a long report I don't have, you know? So, like, I really don't know what the officers know, you know? And there's clearly going to be multiple police officers, multiple victims, but I would just ask the court to consider setting a $50,000 cash or professional bond for Mr. Almanza, no contact with the victims, no contact with any co-defendants or witnesses. If the court can, I would even propose putting Mr. Almanza on a GPS monitor at $1 a day. And if you want, if it's legal, I know it's come up a couple of times, if you can put him on CC sanctions while he's on bond. I mean, I'm trying to do everything I can to give the court assurances that Mr. Almanza will be taken care of and staying basically at home the whole time. So we are asking the court, if the court is going to consider a bond, Mr. Almanza would not object, I don't believe, to any of the conditions that would be placed on it. And I don't even know if he could afford a $50,000 bond. He might sit in jail for all I know. But given the seriousness of what's going on here, I think that it is an appropriate request, and I would ask the court to consider it.
Any rebuttal, Mr. Sprouse?
No, Judge.
So the state is seeking pretrial detention pursuant to Florida Statute 907.041, 5C5, which states, as Mr. Sprouse has previously mentioned, that they have to show that the defendant poses the threat of harm to the community, and the court may so conclude if it finds the defendant is presently charged with a dangerous crime. Again, he is. Home invasion robbery is under paragraph 5A19. There's a substantial probability that the defendant committed such crime. I'm not sure I understand the accessory after the fact angle. I think this is clearly a principal issue, if anything. But the evidence provided is that he set up the meeting. He appeared at the hotel room, and with people who showed up in masks. I think there's a substantial probability that he was involved in planning and implementing the home invasion robbery. As far as the factual circumstances of the crime indicating a disregard for the safety of the community, I certainly understand that from the evidence is that Mr. Almanza seemed to be potentially remorseful and or taking pity on one of the victims at the time this was happening, but certainly set up a situation where there was a disregard for the safety of others when basically organizing this home invasion robbery, that the natural consequences are those that can often lead to people getting hurt or substantially hurt or worse. And then so the final thing is really, are there conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons? And I think that's the issue. I haven't heard anything really about prior record other than what Mr. Kleins had mentioned. I think there was a prior misdemeanor that's pending. It's not even a prior, it's pending still in the juvenile court in the South End. So he doesn't have any adjudications or even withhold of adjudications on any crime that I've heard of or delinquent acts. Clearly, from the evidence, Mr. Almanza was not the one who was doing anything violent. In fact, even the officer had testified it seemed to be that he was trying to prevent some of the more violent issues from potentially happening. So based on that, I think there are conditions of release that could reasonably be sufficient to protect the community from the risk of physical harm to persons. I'll also mention I did read the mental health report that was filed in the past couple of days or so. I've reviewed that and understand that situation. So what I'm going to do is deny the motion for pretrial detention. However, I'm going to grant $100,000 cash or professional bond on the home invasion robbery count. No contact with the alleged victims, no contact with any co-defendants or any other witnesses other than pursuant to discovery process in the case. GPS monitor at $1 per day. He's to not go within 500 feet of the alleged victims, their residences, their schools or places of employment, or their vehicles. Otherwise, that would be a violation of the pretrial release. He'll have to report once per week by phone and once per month in person to pretrial supervision. Don't possess any firearms or any other weapons. Was there anything else that the state would ask for?
No, Judge, you covered it all.
Okay, anything else, Mr. Kleins?
No, Your Honor.
All right, I'll issue the order later today, but clerk's minutes should be suffice.
Your Honor, on the co-defendant, I know 20 minutes ago or whenever, you didn't have an order. I think you said.
I do now.
Okay, I'm looking at the order. So I just-
Apparently, it went to my assistant after hours yesterday.
Okay.
She's homesick, but has actually.
I had just pulled it up and was like, okay, well, here it is. Like,
So I've signed it while we're
Okay.
sitting here in the
All right.
hearing.
all right, thank you, Your Honor.
It was in a different section for me to sign, so. All right. Can I take care of the other juveniles? Because I've appointed them new lawyers or at least the other two co-defendants. I'm not sure who's a juvenile, who's not. Yes, give me Arnett, please. All right. Mr. Arnett, you're here in 2026 CF 320. We're here for your pretrial detention motion. Unfortunately, you were appointed to be represented by the Regional Office of Conflict Counsel, who also represents Mr. Almanza. They filed a motion to withdraw. Were you here for this last week, too? We talked about it a little bit. I was hoping to avoid this, but unfortunately, you haven't been appointed a new lawyer until I'm going to give you yet another one today, and that's going to be Charles Williams. He doesn't know anything about the case and is not here. So my only option really to do at this point is to continue to next week, have Mr. Williams here to represent you at that point. Otherwise, to have you go forward on your own is just not fair to you. So based on that, I'm going to continue this to Thursday, March. All right, so I'm going to have to do an amended order on that one. It's actually going to be Jason Cobb because I didn't realize that Mr. Williams was already on and I thought the public defender had him. Okay, so it is Mr. Williams. All right, so it'll be Mr. Williams. All right, so we're just trying to make sure everyone has a separate, non-conflicted lawyer. And so we'll have you come back on March 5th at 12:30 for that hearing. All right, thank you, Mr. Arnett. If we could have Mr. Cunningham. Mr. Cunningham, you're here in 2026 CF 321, the home invasion robbery count, as well as grand theft and 2 counts of aggravated battery using a deadly weapon. I have to appoint you a new lawyer because the Regional Office of Conflict Counsel is representing one of your co-defendants. I've just signed an order appointing Mr. Marty Nopes to represent you. So we'll have to put you on for next Thursday so he can catch up to speed and come see you about the case so you can be prepared. Otherwise, you'd be doing it on your own. So that'll be next Thursday, March 5th at 12:30. All right. Any concerns or questions, sir? All right. And we'll see you next week. That leaves Dressman. You ready on that one, Ms. Rivers?
Yes, Your Honor.
State ready?
State's ready. We have one witness,
All right.
and we are moving forward on pretrial detention.
Let's bring up Ms. Dressman. Dressman, you're here in 26 CF 335. It's an aggravated battery using a deadly weapon charge, I think a firearm. We're here for your pretrial detention hearing. State's ready to proceed. Ms. Rivers, you're ready to proceed?
Yes, Your Honor.
All right.
State's ready.
All right, go ahead, Mr. Sprouse.
State would call Miss Chris.
swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Have a seat there. Make sure you speak into that microphone clearly. Go ahead, Mr. Smith.
Good afternoon, ma'am. How are you today?
Good.
Can you please say your name for the record?
Caitlin Chris?
Are you employed anywhere?
Yes.
Where are you employed?
Red Rose?
Okay. How long have you worked there?
3 years.
All right. Do you know Leslie Dressman?
Yes, sir. She's in the orange.
How do you know? How do you know Leslie Dressman?
She dates my kid's, she used to date my kid's father.
Do you know where she lives?
Yes, sir.
Where she live?
Across the street from the old Split Oaks, which is like an arcade bar now.
Okay. Does she live next door to your ex?
Yes, sir.
Okay. Like right next door.
Yes, sir. It's a duplex.
Did you come into contact with Miss Dressman on January 15th, 2026?
Yes, sir.
What happened that day? Let's say, where were you at before you had contact with her?
Okay, earlier in the night, I met Reggie Bradshaw at Whiskey Bar, and we had a drink there. And then I went to the Ice House, and then she was there, and I left and went back to Whiskey Bar because she was there. And I didn't want to have no contact. I even bought the drink and didn't even take a sip of it because I saw that she walked in.
So, after the
And
bars...
then I went back.
Let me ask the question.
Okay.
Sorry. After the bars, where did you go?
Okay, after the bars, I went to Reggie Bradshaw's house.
Okay. And did he invite you in?
I knocked on the door and he opened the door for me, and I went in.
Okay. And what happened when you went in?
Me and him proceeded to go into the room, and when we were in the room, me and him started arguing and stuff a little bit. And he's like, just lay down and I'll go take you back to the house later. You know, we'll go back to the house later.
Okay. So y'all are arguing, causing a ruckus in the
Yeah.
room? All right. So you lay on the bed. Did you leave the bedroom?
I had my shirt off and my shoes off.
But did you leave the bedroom?
No, sir, I didn't get a chance to get out the door.
Okay. Why?
Because when we opened the door, she was standing behind the door with a gun.
Okay. And when you say she, you mean Miss Dressman?
Yes, sir.
All right. Can you describe the gun?
It was like a small pistol, about as big as the size of your hand.
Okay. You saw the gun. What happened next?
As soon as I saw the gun, I called 911.
Did you run back into the
Yes,
bedroom?
yes, sir.
Did you try to...
I got behind the bedroom door, and she ended up shooting me when I was going behind the bedroom door. She shot me when I was turning around. She shot me in my arm.
So you get into the bedroom door. Did you try to like barricade yourself from her?
Yes, sir. I was trying to pull the dresser closed. I was trying to pull the dresser closed.
May I approach the witness, Judge? Were you successful in moving the dresser?
No, because she was pistol whipping me upside the head, and the firearm went off again upside my head, and all I could see is gun smoke. And Your Honor, I mean, I don't know how I made it out. I just thank God.
Where did you get shot by this firearm that she was hitting you with?
Yes, I got shot in my right arm. It went in and out. But at the time, when I ran and got to the gas station, got help, I just thought it just went in. And I just thought, I didn't see it go out because it was like on my backside, and I was just panicking because of all the blood.
Are you wearing short sleeves?
Oh,
now?
right now?
Underneath your jacket, are you wearing
Yes.
short sleeves? Yeah, can you take your jacket off? And which arm did you get shot in?
My right arm.
Can you stand up? So. Thank you. Now, were you ever asked to leave?
No, sir.
Mr. Bradshaw didn't ask you to leave ever?
No, sir, not that I can recall.
And what did Miss Dressman say Do you remember if she said anything to you?
No, sir. I only remember that when I listened to the dispatcher call from the investigations office,
Okay.
what was said in there, because literally after she pistol whipped me, I had a hematoma on my head, like a knot on my head.
Did you have a firearm?
No, sir.
Did you have like any sort of weapon with you?
I don't even own a weapon.
Did you have like a knife?
I don't own no weapons.
Did you threaten Ms. Dressman?
No, sir.
Okay, I have no more questions.
Rivers? Cross?
Yes, Your Honor. Is it Chris, as in Criss?
Yes, sir. Yes, ma'am, like cross
Okay.
with an I.
All right, and Ms. Chris, you had testified that you had gone to the whiskey bar, is that correct?
Yes,
Okay. And at the whiskey bar, you had drinks?
one drink.
Okay, and then you talked about later going to another bar, is that correct?
Yes.
All right, do you have alcohol there as well?
No,
Okay. All right, and you indicated that the attorney had asked you, were you invited into the home of where you say just Reggie Bradshaw lived? And you said you went in, but you didn't really answer the question. Did he invite you in?
yes, he opened the door and I knocked on the door and he let me in.
Okay. And you indicated that you didn't get to leave the bedroom because she had a gun, correct?
Yes,
But then also, you had talked about going back into the bedroom, going down the hall, going back into the bedroom, and closing the door. So did you get to leave the bedroom or not?
no, I'm saying I was inside the bedroom and I had to go, when we opened the door opens like this inside the bedroom. And when I opened the door, she was standing right there with a gun. So I had to turn around without stepping foot out the door, and she shot me.
Okay. And so you didn't step foot out the door, and you also mentioned that you had tried to put a dresser or something, like a piece of furniture?
I tried to.
Okay.
I did not succeed.
Okay, but she had already shot you at this point? Or
Yes,
she shot
ma'am.
you? Okay. So she shot you, and then you tried to put a dresser in front of the door,
I-
and then called 911?
Well, I was behind the door. I was trying to pull the dresser behind the door because there's a dresser that lines up with the door, so this door can swing open all the way.
And at this point, she had
I called 911 as soon as I saw her with a gun.
Okay. So you're calling 911
I didn't lay the phone on the dresser.
and lay the phone on the dresser. The door's still open, or is the door closed?
The door, at this point, I was hiding behind the door, so it was like a little tilted, but not, it was pretty much open because,
So the door was open, and you're saying that Ms. Dressman was standing outside the door?
yes.
All
She's
right.
already became,
Just a second. Yes? The witness? Okay. Thank you. Ms. Chris, if you could just back up from the microphone a little bit. You're fine now, but you were
okay.
leaning in and it was causing issues with the recording.
oh,
Just don't get too close. All right, thank you.
And
Go ahead.
was-
I'm sorry to
was-
interrupt.
And was anybody else there?
yes, Reginald.
Okay, and where was he?
He was like trying to fight her off, been trying to fight her off.
So he was inside the bedroom or outside the bedroom?
He was inside the bedroom too.
Okay, so both of you were inside the bedroom?
All three of us
All three of you were in the bedroom?
at this point.
Okay. But at some point, she leaves the bedroom and y'all fight through the door?
You're not understanding.
I know, that's why I'm asking.
I'm saying, this is how it went. She opened the door, we opened the door, she's standing there with a gun. I call 911. At the time when I call 911,
She's just standing there?
I'm on the phone with 911, she's shot me, and I'm turning around to go behind the door. So while I go behind the door, I see that I'm shot, and I'm screaming in the dispatcher call that I've been shot, crying. I laid the phone on the dresser, and I tried to pull the dresser close to me to close it, to get the door closed, to barricade myself in the room.
And where is Mr. Bradshaw at this point?
I don't know.
Okay.
I know
And,
he's in the room somewheres, but
and at what point is it that she was pistol whipping you?
when I'm behind the door hiding, I'm trying to pull the dresser, and she's pistol whipping me, and the fire alarm goes off.
Okay. So are you saying she shot twice?
Yes,
And so you're saying she shot you, then later there's the struggle, then she pistol whips you, and the gun goes off again?
yes,
Okay. And it's your testimony that you were never asked to leave?
yes, that's correct.
Oh.
I don't have anything further, Your Honor, but if I may have just a moment just to confer with my client.
All right, well, any redirect, Mr. Sprouse?
No judge.
Okay. May this witness be excused?
Yes.
You're free to go, ma'am.
State rest.
Ms. Rivers, any evidence?
I'm sorry, Your Honor?
Any evidence, any
Yes, Your
witnesses?
Honor, we'd like to call Reginald Bradshaw.
Bradshaw? Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Make sure you speak into the microphone, sir. Thank you. Go ahead.
Would you please state your name for the record?
Reginald Bradshaw Sr.,
And Mr. Bradshaw, where do you reside?
881A West James Lee Boulevard, Crespi, Florida.
We've heard some testimony about a duplex. Do you live in a duplex?
I rent both apartments.
You
Me
rent
and
both
Leslie live in
apartments?
both apartments.
And do you reside there by yourself?
No,
And who else lives there?
Leslie.
Leslie who?
Dressman, I'm sorry.
Is there a lease?
Yes, there is a lease,
Who is on the lease?
both of us.
You and Ms. Dressman?
Yes.
Okay. Let's talk about January 15th. Did you speak to Ms. Chris that day?
Yes, I did.
Okay. Did you meet up with her at the whiskey bar?
Yes, we did.
Did you invite her over to your house?
No,
Did you ever ask her to, I'm sorry. Did she come over to your house?
yes, she did.
Did you invite her in?
She came to the door, she knocked on the door. She said that she needed to use the bathroom. I said, go ahead, use the bathroom. After that, you're gonna have to leave. I went on with what I was doing in the house. She proceeded to go in the bedroom.
What did you do then?
I was just like, what are you doing? You need to leave.
Did she leave?
No. She proceeded to take her clothes off, said we're gonna have sex. And my answer was no.
Could you tell if she had been drinking?
Yes, she was intoxicated.
All right. And, sir, and you indicated that you had asked her to leave, is that correct?
Several times.
Did you see Ms. Dressman at some point?
Not right then. As I'm asking her to leave, we started to argue. And she's like, I'm gonna ruin your life. I don't want her around my kids and this and that. Leslie,
I'm sorry, let me stop you a
Oh,
second.
excuse me.
She said she's going to ruin your life?
yes.
Did she make threats about ruining anyone else's life?
Well, she said she's gonna ruin me and Leslie's life because she didn't want her around her kids.
All right. And did you observe the interaction between Ms. Dressman and Ms. Chris?
Yes.
All right. Did you hear Ms. Chris testify a few minutes ago?
Yes, ma'am, I did.
Was that accurate?
No, ma'am. Not even close.
Did you see Ms. Dressman just pull the gun and just shoot Ms.
No,
Chris?
ma'am. No, ma'am. Nothing like that.
Did you hear whether Ms. Dressman asked Ms. Chris to leave?
I asked her several times to leave. And then she proceeded to try to barricade herself in the room.
I don't have any further questions, Your Honor.
So you're testifying that the mother of your child was burglarizing your home?
I'm not saying she's burglarizing my home. She said she needed to use the bathroom. I invited her in to use the bathroom. I asked her to leave. She refused to leave.
Okay.
So, if you want to call that burglary, you can call it burglary.
No, you're testifying that she was, you asked her to leave and she
Yes.
didn't leave.
Yes, several
And then
times.
she was trying to have sex with you.
Yes.
Okay. Did you call the cops?
No.
Why not?
She's my
There's a
kid's mom.
trespasser in your home.
We've had these types of issues before.
Okay.
I've asked her to leave, she'll calm down and eventually leave.
Was she shot on
No.
the last times?
No.
Okay. What was different this time?
I just wanted her to leave.
No, why'd she get shot this time?
Objection, Your Honor. Your Honor, he's asking the witness to speculate as to why certain things occurred in the mind of other parties.
I'm going to sustain it, Mr. You can rephrase your questions about actions, but
Yes.
you're asking about why something happened.
Okay. Did you ask Miss Dressman to come over and shoot the victim?
No, sir.
Okay. The victim did get shot, correct?
Yes.
By Miss Dressman, correct?
Yes.
Okay. Do you think that the victim deserved to get shot?
I don't think anyone deserves to get shot.
Okay.
I think accidents happen. And I understand that a gunshot, someone getting shot is not an accident. It's a serious thing, but it was accidental. They
So-
were struggling. She was asked to leave. She refused to leave, tried to barricade herself in the room.
But you know that there's a mechanism of getting somebody from your residence if they're just trespassing and they're not a resident.
Well, sometimes you don't think about those things at that very moment.
Okay.
You just say, hey, you want the person to leave, and they're refusing to leave, and then other things happen.
So, my question to you, do you think Ms. Dressman is justified in shooting the victim?
Yes.
Okay, thank you.
Be direct.
Mr. Bradshaw, did you observe any fighting between the two ladies? Was there any physical fighting, pushing, shoving, struggling?
Yes, when she was trying to get her to leave out the room, she refused to leave the room. Leslie pushed the door, tried to enter the room to get her to leave. They struggled,
Where were you at this time? Were you
standing
inside
in
the
the hallway
room?
by the bathroom, standing
Okay.
in the hallway.
Okay. All right. And was there a struggle?
Yes,
Was there punches thrown?
yes, punches were thrown. It was a struggle.
Did Miss Chris throw punches? Or did she swing out and hit?
I'm going to say yes. I mean, they were struggling. At that point, I'm trying to get both of them to calm down.
And you indicated that the shooting was an accident?
Yes, yeah.
Take your seat, sir.
Thank you.
Any other witnesses or evidence?
No, Your Honor, sorry.
Any rebuttal?
No, Judge.
Its argument for pretrial detention?
Yes, Judge, we're here for a pretrial detention hearing where the state needs to prove that the defendant is charged with a dangerous crime. She is aggravated battery with a deadly weapon is a dangerous crime. Substantial probability that it occurred. I think given the testimony from the victim and the witness, it is clear that Ms. Dressman intended to use a firearm to batter the victim. Whether the state's position on an accidental discharge of a weapon there's just not such thing. If you pull the trigger of a firearm, a loaded firearm, that intent of pulling the trigger now follows that bullet. So there's a substantial probability that Ms. Dressman did commit this crime. Third prong, more difficult to prove that there is no condition of bond that would ensure the protection of this community from physical harm. This is it does appear that this is an isolated incident where the victim and the defendant do know each other. However, these actions by the defendant in a duplex shows a complete disregard for safety of others, complete disregard for firearm safety, and the state believes that Your Honor should grant the motion. Thank you.
Miss Chris came into the home of both people. As she said, it was only the home of Mr. Bradshaw, but it was the home of Miss Dressman and Mr. Bradshaw. Mr. Bradshaw indicated they were both on the lease. So she comes to her own home. She is, there's this argument. She tells her to leave. She hears Mr. Bradshaw tell her to leave. She tells her to leave. The woman would not leave. The woman is not dressed. The woman has been under the influence of alcohol, and she vowed to ruin Mr. Bradshaw's life and Miss Dressman's life. Mr. Bradshaw testified to that. Mr. Bradshaw also testified about how they were struggling. Mr. Bradshaw's testimony was vastly different in many facets than Miss Chris. It appears clear that Miss Chris clearly doesn't like Miss Dressman and doesn't want her around, and that she wants to be back into that home. And I think the court has to consider her credibility when determining a bond. I would also submit to the court, if the court looks, you will see that Miss Dressman has no criminal record whatsoever. And she was in a place where she was allowed to be and confronted by someone under the influence of alcohol who was vowing to ruin her life and who was being combative. And the testimony of Miss Chris is just not lining up with, I submit, the testimony that's in the police report and the testimony that she's given here today, that they don't line up, they don't match. She's giving different testimony because she can't remember it correctly because she's not telling the truth on that respect. Was she injured? Of course she was injured. But the position of Ms. Dressman and the position of Mr. Bradshaw is that it was an accidental discharge. Based on the fact that Ms. Dressman has no criminal history and was in her own home, we're asking the court to consider a cash professional bond.
Anything else, Mr. Sprouse?
Your Honor has the police report, so I don't believe it.
It hasn't been introduced into evidence, so it won't be considered.
I proffer that the testimony of like how this occurred is substantially the same. The victim who got shot in the arm might be a little bit excited when recalling these actions. Your Honor saw it. Mm-hmm. So to hold that against her of whether she stepped into the hallway or didn't step into the hallway, whether she passed the threshold is, I think, de minimis. Thank you, Judge.
All right. So this is a pretrial detention hearing. I can make a decision based on the evidence that's been presented. And just going through the factors of 907.041, 5C5 is whether or not the defendant poses a threat of harm to the community. She is charged with a dangerous crime. As far as a substantial probability that the defendant committed the crime, substantial probability. There was certainly probable cause found at first appearance. I'm not quite sure what happened, and so I think when I'm not sure, I don't know what probably happened. It's pretty clear, according to the testimony of Mr. Bradford, that the alleged victim in the case, Miss Chris, was, although invited in initially, was told to leave several times by both Mr. Dressman and Miss Bradford. I'm not sure. I know Mr. Bradford said that Ms. Dressman lives there too, but it's a duplex, and who lives in which one, and I'm not sure that's something I have to parse out today. But she was told to leave. I don't think anything in the statutes regarding justifiable use of force or standing your ground allows for firearms to be used against people who are unarmed and maybe committing a trespass, which is a misdemeanor. But those are factors that will, or issues that will be decided during the course of this case as it progresses. However, based on the evidence, I'm not quite sure what happened, so I'm not sure there's a substantial probability that the defendant committed this crime. And I don't see this as showing, I mean, there's some disregard for the safety of the community. I don't think even in your own home you should be brandishing firearms and trying to strike people if they're unarmed, especially as kind of a first resort. But I also think there are conditions of release that reasonably would be sufficient to protect the community. So I'm going to deny the pretrial detention motion. But so at this point, it's a bond hearing. So does either side want to be heard on a cash or professional bond?
They would ask for $75,000 cash professional on the aggravated battery and a GPS monitor.
Okay.
And no contact
No
with the victim. As far as the state's witnesses, she can have contact because she lives with Mr.
Yes.
Bradshaw.
Yes. Okay. All right, Ms. Rivers.
Your Honor, we would ask that the court consider no more than $25,000 cash or professional, understand with pretrial services, ankle monitor, we would ask for less, but please no more than $25,000 cash or professional. And of course, all firearms.
Sure. All right. When determining bond, the court has to look at three different things. We all know this. But it still is worth putting on the record is whether someone's a danger to the community. I just talked about that. Whether someone is a flight risk and whether someone is going to cause an issue with the integrity of the system. I've talked about the danger issue already. I don't believe Ms. Dressman is a flight risk. I think flight risk can be deterred by things like GPS monitors. I don't even think that's necessary at this point. It'll be a $25,000 cash or professional bond, no contact with the alleged victim, Ms. Chris. Don't go within 500 feet of her home, her vehicle, her place of employment, or her person. No use or possession of any firearms, Ms. Dressman. I'm assuming that the firearm used in this situation has been taken into evidence by law enforcement. But as far as any firearms that you may have other than that one, Ms. Dressman, those will either, there's a couple of different ways of doing it. Giving them to someone else so they're not in your possession can be done through through an affidavit, but I'm going to have pretrial supervision who's going to supervise you. Verify that you've done that, or you surrender them to the sheriff's office, and you're going to have 1 week to do that and provide proof to pretrial services that you've done so. Pretrial services will be a call-in once per week, but no in-person. Anything I've missed, Mr. Sprouse, that you would ask for?
No, Judge.
Okay. All right. Thank you. Yeah, I'm going to go straight down to 130. All right, everyone. I'm Judge Oberliesen. We're going to start our arraignment docket. That was set for 1:30, so we're about 17 minutes running late because we had a bunch of pretrial detention hearings today. What I'm going to do is I'm going to call up each person who's on our arraignment docket. I'm going to do it alphabetically, so you should know when you're coming up. It's alphabetical by last name. I'm going to call you up, tell you your case number, what you're charged with. Make sure you understand that. Make sure an information or charging document's been filed against you. If you don't have a lawyer who's here for you or one that's been appointed, I'll talk to you about whether or not you would like a lawyer to be appointed to represent you. Mr. Russell, you have Adkins on it, but that's not an arraignment, is it? Oh, I guess there's the new case, isn't there?
Well, yes, sir. This is a follow-up status hearing. Last time we were in court, I had confirmed that he was down in Orlando, and the court passed it to today to see if we could get some updated information. I was not able to reach the person down at Phoenix Housing that I spoke to last time, and so as far as I know, nothing's changed. That's all I can tell the court.
Unfortunately, with this case, I'm not sure of no news is necessarily good news. I hope that to be the case, Mr. Russell.
Yes, sir. I have talked to probation. They say they have contacted probation, their counterparts down there. So probation down there is supervising him, apparently.
Mr. Barry, you're nodding your head back there.
That's correct, Your Honor. We transferred him to that area.
Okay. I only have his old cases listed in my docket here. What's the status of the 25 case, Mr. Russell? I'm trying to pull it up, but it's...
That was passed, Judge, for the state to decide if they were going to pursue the charges or not. I think Ms. Leon was going to look at it and make a decision. Herbert Atkins, 25 CF 2471.
Oh, that's my,
No, it's
Oh, is that yours?
oh, sorry, Atkins animal?
No, it's
Oh,
not.
sorry.
It's not the animal.
Excuse me.
No, it's Herbert Atkins.
Sorry.
You know, the state is dismissing the charges against Mr. Atkins.
In 25 CF 2471.
Yes, the new case that hasn't been filed on.
Okay. So basically, where we're at now is in the old case, Mr. Russell. He's on probation and being supervised in his new housing.
Yes, sir, that's correct.
I don't think we need another court date.
No, sir. Thank you, Judge.
Thank you, Mr. Russell. All right, Tommy Allen. Oh, okay. Dexter Bearfield. Jail list. All right, Mr. Bearfield, you're here in 26 CF 114, charged with domestic battery by strangulation.
Yes, Your Honor.
Well, I don't have the information in front of me, so I want to.
Sir, it's just copy your charging document, okay?
Yes, Your Honor. We'll enter
Also, I'm sorry, also tampering with a witness and resisting without violence.
Yes, Your Honor. We'll enter a plea of not guilty at this time. Demand trial by jury.
All right. You all want the April pretrial
Yes, Your Honor.
date? All right, it's going to be April 29th at 9 o'clock. Mr. Bearfield, if you do bond out before then, you'd be on the 27th, that Monday instead of Wednesday. But for now, April 29th. Thank you.
Thank you, Your Honor.
Nathan Barnhill. Mr. Barnhill, you're here in 26 CF 199, charged with 2 counts of possession of a controlled substance, third-degree felonies, and possession of narcotic equipment, a first-degree misdemeanor. Mr. Maddox?
Yes, Your Honor. Your Honor, we'll enter a plea of not guilty at this time. Demand trial by jury.
April 27th at 1 p.m. will be your next court date. So pretrial conference, stay in touch with Mr. Maddox, your lawyer. David Beck.
served misdemeanor.
All right,
Yes,
Mr.
sir.
Beck, you're here in 26 CF 149 with felony petty theft.
Yes, Your Honor. We've reached a resolution in this matter. I'm just finishing writing up right now.
Okay, we'll bring you back, Mr. Beck, and you can finish up the paperwork.
Yes, sir.
Thank you, sir.
All right, Sarah Black. Sarah Black, 26 CF 110, possession of controlled substance, possession of drug paraphernalia.
Yes, Your Honor.
Yeah, so I can sign?
Yep. I just need to finish writing it up. We're going to have a resolution in this matter, Your Honor.
All right, so it's past Ms. Black for a plea later.
All right. Take this, ma'am.
Why is Joseph Carroll listed on this docket?
He's moved to the 2 o'clock docket.
He's 2 o'clock, okay, that's what I thought, Roy Chamness. Chamness is here in 26 CF 237, charged with failure to register.
Yes, Your Honor. Your Honor, went to your plea of not guilty today. The state and I have discussed this case previously, Your Honor. It's a very strange set of circumstances. I need to meet with Mr. Chomness. I'm going to do that immediately as soon as I can get him scheduled in. We may be able to resolve this case sooner rather than later, Your Honor, just so for the court's benefit. But I will go ahead and leave him set for the pretrial conference for now.
All right, so it's going to be April 27th at 1 o'clock, Mr. Chamness. If they all get it worked out and they can come in for an early plea, you can schedule an earlier date.
Yes, sir.
As soon as possible, make that
All
appointment.
right, Timothy
Yes, sir.
Kami.
Thank you, sir.
Just thought they told you he's not here.
Yes, he's an inmate, Your Honor.
Oh, Conway. All right, Timothy Kami, this is 26 CF 145, burglary, unarmed dwelling, grand theft, and resisting without.
Enter plea of not guilty to, Your Honor, demand trial by jury.
Is 24 CF 1657, is that a new VOP?
Yes, Your Honor, it is.
All right, so denial?
Yes, Your Honor,
Want
denial.
that to go along with the new case?
I do, Your Honor.
All right, that's going to be April 29th at 9 a.m. for pretrial conference for both cases. Plea of not guilty and denial been entered.
Thank you, Your Honor.
All right, Brandon Conway.
You're good, sir.
You're the guy that said it was.
I'll come talk to you about that.
Oh, wait, he pled.
Sorry?
Brandon Conway.
Yes, he did, Your Honor. Time served, offer yesterday. He was set to be arraigned today on that new case, the lewd and lascivious.
Oh, lewd and lascivious exhibition. Okay,
Yes,
I remember him now.
26 CF 129.
All right, so he's already resolved. Thomas Craig. Mr. Craig's here in 26 CF 106.
Yes, Your Honor. All right, sir.
Possession of controlled substance, possession of paraphernalia.
Yes, Your Honor. Went to your plea of not guilty at this time. Demand trial by jury.
All right,
That's for you,
Mr.
sir.
Craig,
Take
it's
that.
going to be April 27th at 1 p.m. will be your pretrial conference.
Thank you, Your Honor.
Thank you.
You're good, sir. Call my
Stephen
office.
Creech. Should be you. All right, Mr. Creech is here in 26 CF 127, charged with possession of a firearm by a convicted felon in violation of an injunction against domestic violence.
Yes, Your Honor. Went to your plea of not guilty at this time. Trial by jury.
April 29th at 9 a.m. for pretrial conference.
Yes, sir.
Okay. Go ahead, Your Honor. Mr. Creech wishes to address the courts against my advice. Go ahead, sir.
Your Honor, sir, if I may,
Hold on a second. If you're going to talk, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
All right, your attorney said that you're going to speak against his advice. I'm going to tell you that anything that you say can and will be used against you in the investigation and prosecution of your case. Everything in this room is recorded.
Yes, sir, Your Honor, I understand. That's why I would like to say this for the record, on the record.
You got to understand this is not a trial,
Yes, sir.
and I won't be making any evidentiary decisions today.
Correct, sir. But
This is just your file, sir. That's your paperwork. I don't have anything that we talked about on here.
for case
26
number-
127.
4626CF000127 AC, Your Honor.
Hold on.
Already announced the case number, Mr. Creech. Go ahead.
Before
they-
he speaks, may I approach, Your Honor?
Yes. Mr. Creech.
Your Honor, they have charged me with violation, injunction, domestic violence, possession of firearm/ammo. It was a shell. It was not a firearm.
Well, it's possession of firearm, ammunition, or electric.
Well, here they have got me.
Your charging document says ammunition.
They've got me charged with violation, injunction, domestic violence, possession of firearm/ammo. And then, Your Honor, they got me or ammo by convicted Florida felon.
That's the charges right there,
They've
sir.
got me charged with a double jeopardy violation of my constitutional right, my Fifth Amendment. It's a double jeopardy clause, Your Honor. They have charged me twice for the same incident.
You're looking at an arrest report? What
I'm
you're-
looking at my
Mr.
charge.
Creech, if I could.
I'm looking at my charging document, Your
That's
Honor.
not a charging document.
Well, what is it
Right
then?
The charging document is what your lawyer's pointing to. What does it say on the top of it, Mr.
Can I plea out to the possession of ammo?
No, sir.
30 months probation today, Your Honor?
No, sir.
I don't negotiate. That's for you and the state to do.
I'm asking. I'm giving it'd be a no contest plea, straight up, 30 months probation.
No, sir.
What about, can I, no contest plea, 12.1?
No, sir.
No,
I don't know anything about your history or anything else. So it's not going to happen today, Mr. Creech.
Why not? I mean,
I just
I don't
told
want to
you.
be here 10 more months to get the same, possibly 12.1, Your Honor.
Well, you'll
I
get
like to get this
You'll
closed
get
today.
credit for any time you serve, Mr. Creech. Thank you. We'll
Now-
see you on April 29th at your pretrial conference.
All right, thank you.
Can I have this?
Yes, that's your copy. Appreciate the court's consideration.
Kevin DiLorenzo, am I saying that right? DiLorenzio. I think I missed it. How do I pronounce the last name, sir?
DiLorenzio.
DiLorenzio. All right, Mr. DiLorenzio, you're here in, your new case is 26 CF 80, possession of a controlled substance, but you also have two VOPs, 23 CF 1858 and 2393.
Yes, Your Honor. That's your charging document. Yes, sir. At this time, you will enter a plea of not guilty, Your Honor, demand trial by jury.
Didn't that we do that last?
No, we went
Also-
to the denial on the
The
VOP.
2023, I'd like to get that out of the way so I can bond out on my new charges.
I'll come talk to you about that.
Okay, when? You didn't come and talk to me this week.
That's true. I'll come talk to you today. I'll be there.
Today?
Yes, sir.
Okay, when are we getting continued till, or whatever?
It'll be April 29th because he's in
29th, I'm
custody.
sorry.
Yeah, I've got a case in Your Honor, if I may.
Sure, go ahead, sir.
Okay, I've got a case.
He's going to put you under oath first, if you
Okay.
want to
It's
address
fine,
the
let's
court.
just move on. What do you want to tell me, Mr. DiLorenzo?
Okay, I've got a case from 2023. I've got 13 months credit on that case for 2 charges of petty theft and a criminal mischief. I was wondering if I
You
could.
talking about your VOPs?
Yes, Your Honor, I believe so.
Yes. those
Yes,
as
I
well.
just told you, you're here on your VOPs.
Okay, so I've got 13 months credit on that, on my
Okay.
2023. And I would like to get that out of the way so I can bond out on my
What do you
new
mean, get it out of the
charges.
way?
Get time served possibly with my 13 months credit.
Has the state offered time served?
Not to my knowledge, state have an offer even remotely close to that.
13 months credit on
Am
my.
I wrong that he was charged with burglary with battery, or did he not plea out to that?
That was dismissed.
I don't believe that's what the offer is.
It's a guideline, it's a DOC offer.
Okay.
What are his guidelines?
What's that score?
That burglary with assault was
sir.
dismissed.
Sir?
She's got your
I just have on here that I mean,
Okay, no, I'll check. I'll go talk with
not
him.
really prepared to make an offer.
No, of course, I understand.
All right, this is what I'm going to do, Mr. DiLorenzio. I'm going to put all of your cases on the April 29th date at 9 o'clock. However, if your lawyer talks to the state and y'all work something out that can resolve it faster than that, I have other court dates we can put on where we can accept a plea or whatever else that needs to be done before then. But if they're not willing to make you an offer, I'm not taking pleas and I'm not negotiating with you about it today. It's just not what today's about.
I'll come see you today.
Okay.
All right, thank you. Denial on the VOPs. All right, Teresa Edwards. All right, Ms. Edwards, you're here in 26 CF 171, charged with felony battery.
Yes, Your Honor, what's your plea of not guilty at this time? Demand trial by jury.
April 27th, 1 o'clock.
Appointment, okay.
Okay, all right, thank you, Landon.
Yes, ma'am.
Landon. Thank you, Your Honor.
All right, Cecil Espino. All right, 26 CF 172, possession of a controlled substance, possession of narcotic equipment.
Yes, Your Honor, what's your plea of not guilty at this time? Demand trial by jury.
April 27th, 1 o'clock for your pretrial conference. Mr. Espino, stay in touch with Mr. Maddox.
Sir, thanks.
Thank you.
David Fiducia.
Sir. Yes, sir.
Mr. Fiducia, you're here in 26 CF 202, charged with burglary of an unoccupied conveyance, third-degree felony, grand theft auto, third-degree felony, violation of driver's license restriction by a habitual offender,
Charging document.
third-degree felony, and criminal mischief, third-degree felony.
Yes, Your Honor, what's your plea of not guilty at this time? Demand trial by jury.
April 29th at 9 a.m. for pretrial conference. Joseph Gainey. Mr. Gainey, you're here in 26 CF 146, charged with aggravated battery.
Yes, Your Honor. Ms. Goodman. Sorry, Your Honor. Enter a plea of not guilty and demand trial by jury.
All right, Mr. Gainey, you're going to be April 29th at 9 a.m. for pretrial conference.
Yes, sir.
Did you get any information on him? Yeah, I see it too. I just want to make sure you got it. All right. All right. Desiree Glover. Ms. Glover, you're here in 26 CF 185. You're charged with trafficking in amphetamine or methamphetamine, 28 grams or more, and possession of drug paraphernalia. You don't have an attorney that's currently representing you. Are you going to hire one, Ms. Glover? Ms. Glover? Okay, can you take your hands out of your pockets? All right. You're not going to? Can you afford an attorney? All right, do we have applications here? All right, I'm going to provisionally appoint the Public Defender's Office, but you're going to have to fill out this application I'm giving you. Fill it out today and turn it in before you leave on the first floor in the clerk's office. I think, Mr. Maddox, that would still be you.
Yes, Your Honor.
Okay, so what would you like to do now that I provisionally appointed you?
Oh, sorry, Your Honor. Yes, we'll enter a plea of not guilty, demand trial by jury. Frowned upon, turning back on the court.
No, it's, I just wanted to make sure you knew this was going to be yours. April 27th at 1 p.m. will be your court date, Ms. Glover. Make sure you stay in touch with Mr. Maddox, but 100% get that form filled out and turned in before you leave here. All right, Amy Gould. All right, are you Ms. Gould?
Yes, Your Honor.
All right, Ms. Gould, you're here in 26 CF 182. You're charged with possession of the personal identification of a deceased person and petty theft. Do you understand those charges?
Yes, Your Honor.
All right, you don't have an attorney. Do you plan to hire one?
No, Your Honor, I'm not unable.
Okay, you're not unable to afford one?
Correct.
Okay, so just like the last person, I'm going to give you that application. Fill it out, bring it down to the first floor clerk's office, and turn it in before you leave here today. This is Mr. Maddox from the PD's office, Public Defender's office. I'm going to appoint him or his office to represent you provisionally, but you still have to turn in that application.
Yes, Your Honor.
Your court date's going to be April 27th, and not guilty pleas being put in for you.
Thank you,
That'll
Your
be at 1 p.m. Stay in touch with Mr. Maddox.
Yes, Your Honor. Thank you.
Thank you.
All right, thanks. Give me a call. Let me give you a call.
Megan Greek. All right, Ms. Greek, you're here in 26 CF 89, charged with possession of a controlled substance as well as smuggling contraband.
Yes, Your Honor. I do believe we're going to have a conflict in this case. It looks like there's a co-defendant, Robert Escald. So I will submit that conflict and see what we end up doing with it. I'd imagine we'd keep the older case, Your Honor, but I'm not exactly sure. So I'll get an answer for the court as soon as I can.
All right, so Ms. Greek, what I'm going to do at this point is, well, she doesn't even have a public defender appointed.
I had to complete the, excuse me,
I saw
sorry.
in our system.
I just have to, there was a problem with my application. I had to put a dollar amount, so I need a new one to fill out.
Okay, if you could fill one out now and go turn it in. You're going to fill it out and bring it downstairs.
Oh, okay.
You're not going to do it up here in the courtroom.
Okay.
You got time, is what
Okay,
I'm saying.
cool.
You don't have to try to quickly do that because you want to make sure you get it right.
Okay.
All right, Ms. Greek, I'm going to put you on April 27th at 1 o'clock. Provision appoint the Public Defender's Office, but as you heard, they may have a conflict 'cause they represent someone else who's involved. Let them determine that. They're appointed to your case in the meantime, but there may be a situation where I have to appoint a different office for you. So just stay in touch with Mr. Maddox until we know for sure how that's going to work.
Yes, Your Honor. If we didn't already, we'll enter a plea of not guilty.
All right, April 27th, 1 o'clock.
Thank you.
Thank you, ma'am.
All right, Charlie, is it Gullet or Goulet? Goulet? You never know. So, say again?
Nobody's ever said that correctly.
What's that? Gullet. Well, it was my second. It was my second option.
Everybody
I would've
says
said
gullet.
Yeah, I
Gullet.
would have said gullet. I wouldn't even been close. All right, Your Honor, the same thing in this case. I do have a conflict in this case. I do believe we may have already submitted a motion to withdraw in an order, but if not, I'll certainly get that to you.
What does that mean?
We just have to withdraw from your case.
Motion to withdraw.
RCC,
There is an order.
Regional Conflict Council. So you get another attorney to
All right.
represent you.
Oh, because you
That order is
have the-
here.
has
I'm
the
going to
same
go ahead
attorney.
and sign it. So
Okay.
what's going to happen, Ms. Goulet, is you're going to come back on April 27th at 9 a.m. You're going to be represented by the Regional Office of Conflict Counsel. That's Mr. Klein's. He happens to be here. So if you want to talk to him for a quick second on your way out, we'll see you back on April 27th at 9 o'clock.
Okay.
Heather Hiker.
I'm sorry. Yeah, same thing happened at the jail last night, Judge. They said hiker, and it sounded to me like hiker. I was going, no, I don't recognize.
Well, they're both H, right? All right, Ms. Hiker, you're here. You've got a violation of probation in 13 CF 1808, as well as a new case of 26 CF 78 where you're charged with felony battery. Mr. Williams?
Judge, on Ms. Hiker's case, I'm going to enter a plea of not guilty, request 15 days for pre-arraignment motions, trial by jury. It looks like she's got a VOP. Pass that to track with this one.
Okay, they'll both be put on April 29th at 9 a.m. Not guilty and denial have been entered.
Thank you, Judge.
All right, thank you. Zachary Henderson.
Oh, Ms. Hiker. I'll bring it out to you, or I'll mail it to you.
All right, Mr. Henderson, you're not currently represented. Are you hiring a lawyer, or would you like me to appoint you one?
I need to be appointed one.
Okay. All right, I'm going to go ahead and provisionally appoint the Public Defender's Office. You're going to have to fill out an application, but you can do that through the jail. You're here in 26 CF 184. You're charged with possession with intent of a hallucinogen, is that right?
There you go. Judge, I'll enter a plea of no.
Sorry, let me fix that, because my docket says one thing, but the information says something else. You're charged with trafficking in amphetamine or methamphetamine, 28 grams or more. Drive on license suspended or revoked, possession of drug paraphernalia. Is he the co-defendant?
Possession of drug paraphernalia, stuff you used to smoke.
What do you say about 28 grams?
Allegedly.
Let me see your.
Is he the co-defendant of Glover? All right, so
28 grams or more of methamphetamine.
No.
Well, that's-
Mr. Williams, there's a co-defendant that I've already appointed to PD as well, so y'all have to figure out which one you're going to stay on.
Yes,
But Mr. Henderson, if ultimately they get off of your case, it'll be the Regional Office of Conflict Counsel, but they have to make that determination first. So as of now, it's going to be April 29th at 9 o'clock for your pretrial conference. Catherine Hughes.
Somebody will be out to see you.
Ms. Hughes, you're here in 26 CF 201, where you're charged with aggravated assault on someone over the age of 65 and battery on law enforcement officer.
Judge, I'm in a plea of not guilty on her behalf. Request 15 days for pre-arraignment motions and trial by jury.
April 29th at 9 o'clock for pretrial conference. Sydney Jenkins.
All for you to take. Yes, ma'am.
Sydney Jenkins here. That's not on my jail list. Maybe it came off and I've got an old docket still. Yeah, it's not showing up. Can you pull up Sydney Jenkins, 26 CF 104, and see if was a plea of not guilty in advance? Roger Lee. All right, Mr. Lee, you're here in 26 CF 225, where you're charged with possession of a controlled substance, and that's it, third-degree felony. Mr. Williams?
Judge, I'll plea of not guilty on his behalf. Request 15 days pre-arraignment motions. Trial by jury. Call the number on there.
All right, April 27th at 1 p.m. will be your court date, Mr. Lee. We'll see you back on that day. Stay in touch with Mr. Williams.
Thank you.
Put that one on April 27th at 9 o'clock if you haven't already. All right, Michael Livingston. Did we address him yesterday?
We did, Judge. We had pretrial conferences.
Okay. Travis Madden. Travis Madden here? Oh, okay, I'm sorry, I didn't see him. Mr. Madden, you're here in 26 CF 349, where you're charged with possession of a controlled substance, third-degree felony. You don't currently have a lawyer. Can you afford a lawyer to represent you? Would you like me to appoint you one?
Yes, sir.
All right. I'm going to have you fill out one of those forms and bring it down to
Yes,
the
sir.
clerk's office on the first floor, but I'll provisionally appoint the public defender's office to Mr. Madden.
I'll make an appointment to come see me, okay?
Yes, sir.
Judge, I'll enter a plea of not guilty on his behalf, 15 days pre-arraignment motions, trial by jury.
All right, April 27th at 1 o'clock, Mr. Madden. We'll see you back on that date. Make sure you turn that application in before you leave today. All right, Richard Mandolini.
Judge, we have a negotiated plea, and Mr.
Afternoon, sir.
Nope, I've got one.
You got the score sheet. Thank you, Mr. Williams. All right, Mr. Mandolini, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Can you state your full name and date of birth, please?
Richard Mark Mandolini, 4/12/71.
All right, Mr. Mandolini, you're here in 25 CF 2246, where you're charged with possession of a controlled substance, third-degree felony, and felony petty theft. That's a third-degree felony, both of which are punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plea no contest as charged, be an adjudication of guilt, so that's 2 felony convictions, time served, be concurrent, 615 court costs, and a $150 PD fee. I can give you 90 days to either pay that or set up a payment plan. Is that what you want to do here today?
Yes, sir.
Or did you go over this plea form with your lawyer?
Yes,
Did you understand and sign it?
sir.
I don't have a state attorney signature on this one. Mr. Williams, can you have the state sign that? All right. But you signed it, Mr. Mandolini, right?
Yes, sir.
Okay. Do you need more time to speak with your lawyer?
No.
Are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've previously announced? And do you understand that by entering a plea there won't be a trial of any kind? And do you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of that agreement you've already signed? And do you understand you're waiving all potential defenses? Do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? And based on all that, what is your plea to the possession of controlled substance and felony petty theft? All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. This is a guideline sentence as you scored 30.6 points. Adjudication of guilt, time served on each case, 615 court costs, 150 PD fee. You're gonna have 90 days to pay that or set up that payment plan. I do need you to be fingerprinted, Mr. Mandolini, and then you have 30 days to appeal the judgment and sentence of the court. Thank you, sir. Good luck. Andrew Marshall. Marshall, you're here in 25 CF 1667, which is a violation of probation, and also 2026 CF 191.
Judge, I'm going to enter a plea of not guilty on his behalf, 15 days pre-arraignment motions, trial by jury.
All right, denial on the VOP.
That's correct, Judge. I thought I'd already handled that, so.
Okay, you may have, but just based on what my docket says, I want to make sure we got that. Do you want them both to run together on 4/29? All right, Mr. Marshall, April 29th at 9 o'clock will be your pretrial conference for both your cases. We'll see you back on that date.
All right, sir.
Ashley Mason. This is Ashley Lamar Mason, 26 CF 109, where you're charged with possession of controlled substance and possession of narcotic equipment.
If I can have a brief moment, Your Honor.
Go ahead.
Sir, do you want to do that?
No approval.
Probation.
No.
Judge, if we can pass him, I'll go out in the conference room and go over his rights with him.
All right, it's past Mr. Mason for a plea. We'll bring you back later this afternoon, sir.
Here, go ahead and take this with you.
All right, Clovis McClellan. All right, Mr. McClellan, you're here in 26 CF 81, charged with felony driving while license suspended.
Judge, I'm going to enter a plea of not guilty on his behalf, 15 days pre-arraignment motions, trial by jury.
Mr. McClellan, your pretrial conference date is going to be April 27th at 1 o'clock. Be back on that date. Stay in touch with Mr. Williams.
Sir.
Thank you, sir.
Thank you,
Edward
Judge.
McTeer.
Oh, sir.
Mr. McTeer. All right, Mr. McTeer, you're here in 26 CF 142, charged with failure to register as an SO offender regarding a vehicle. Mr. Williams?
Judge, all right, Judge, I'll enter a plea of not guilty on his behalf, trial by jury, 15 days for pre-arraignment motions.
All right, Mr. McTeer, it's going to be April 27th, 1 o'clock for pretrial conference. Come back on that date. Stay in touch with Mr. Williams.
Yes, Judge.
Thank you.
Here you go, Mr. McTeer.
Ethan Montaldo. Mr. Montaldo, this is 26 CF 189, where you're charged with possession of burglary tools, third-degree felony, and trespassing, first-degree misdemeanor.
Judge, I'll enter a plea of not guilty on his behalf, 15 days pre-arraignment motions and trial by jury.
April 27th, 1 o'clock for pretrial conference. Stay in touch with Mr. Williams. E. Moore.
Just a second.
Yes, I'm not prepared to do anything today.
Judge, I'm going to enter a plea of not guilty on his behalf, trial by jury, 15 days pre-arraignment motions.
All right, that's on 26 CF 100. And then there's the VOP. You want that to track with it?
Yes, sir.
All right, April 29th at 9 o'clock. Mr. Moore, we'll see you back on that day.
All right, thank you, Judge.
Elijah Murray. Murray, you're here in 26 CF 152, where you're charged with home invasion robbery while wearing a mask. It's punishable by life in prison and grand theft, third-degree felony.
Judge, I'm going to enter a plea of not guilty on his behalf, 15 days for any pre-arraignment motions and trial by jury.
All right, Mr. Murray, it's going to be April 29th at 9 a.m. for your pretrial conference. Logan Myers. Mr. Myers, you're here in 26 CF 211. You're charged with possession of a controlled substance and false ID to law enforcement. I don't see, oh, there's the information. Mr. Myers, you're not currently represented. Can you afford an attorney to represent you?
No, sir.
Okay. I'll have you ultimately fill out one of those applications in the jail, but I'm going to appoint the public defender's office to represent you provisionally.
Yes, sir. Judge, I'll enter a plea of not guilty on his behalf. Request 15 days for pre-arraignment motions and trial by jury.
All right, Mr. Myers, it's going to be April 29th at 9 o'clock for your pretrial conference. Anthony Nitsky. Mr. Nitsky, you're here in 26 CF 170, charged with possession of a controlled substance and paraphernalia.
Judge, we've got a negotiated plea in Mr. Nitsky's case.
Mr. Nitsky, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
Anthony Michael Nitsky, date of birth 3/13/1995.
All right, Mr. Nitsky, you're here in 26 CF 170, where you're charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, and possession of paraphernalia, which is a first-degree misdemeanor and punishable by up to a year in county jail. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plea as charged, nolo contendere, and to be an adjudication of guilt, credit for time served, $615 court costs, $150 PD fee, and I'll give you 90 days to either pay those costs or get on a payment plan with the clerk's office.
Yes, sir.
Is that what you want to do today?
Yes, sir.
Did you go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Absolutely.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
You understand there won't be a trial of any kind if you enter this plea?
Yes, sir.
And you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of that agreement you signed?
Yes, sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation and/or exclusion from the country?
Yes, sir.
And Mr. Nitsky, what is your plea?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty. That's 2 felony convictions. You can come up, Ms. Flowers. Credit for time served, $615 court costs, $150 PD fee. I'll give you 90 days to pay that or set up that payment plan. It appears that this is a guideline sentence. You scored 25.2 points. I need your fingerprints, Mr. Nitsky, and then you have 30 days to appeal the judgment and sentence of the court.
Thank you, Judge. And
All
I'll
right,
go
thank
see,
you. All right. Nicholas Pittman. All right, you Mr. Pittman? Okay, Mr. Pittman, you're here in 26 CF 76 where you're charged with fleeing and attempting to elude a law enforcement officer, third-degree felony. You don't have an attorney here with you. Are you going to hire one, or do you want me to appoint you one?
No, I don't need one.
You don't need one.
Yeah. No, I don't need one.
So what are you going to do here today?
I'm representing myself.
Okay. Well, this is what I'm going to do. I'm going to put you on for a pretrial conference. At that pretrial conference, we'll have what's called a Feretta hearing, where I can determine whether or not you're competent to do that.
Yeah, all right.
Is there a problem, Mr. Pittman?
I don't need all that, man.
It's required by law.
Yeah, whatever.
What do you mean by whatever?
Man, do what you're doing, man. I'm pleading not guilty. Set my trial date so I could go, man.
I'm going to pass your case.
That's cool.
All right, we'll see you in a little bit, Mr. Pittman. Say again? All right, come on back up. You're not going to make a mockery of this courtroom, Mr. Pittman.
Mockery, but I'm not, brother, I'm not incompetent or nothing. I represented myself last time and beat all the charges. Why I gotta go through this?
Are you done? It's not about competent to proceed. It's whether or not you're competent to represent yourself. One of the questions I'll ask you is if you've ever done that before.
Man, ain't shit in my pockets. I went through the metal detector, bro. Yes, okay. Yes, sir. What I need to do?
I think you need to calm down and have a different attitude when you come back.
So I got to come back today? Or can I go ahead and plead out?
What would you like to do?
Not guilty, man.
All right. I'm going to accept your not guilty plea. Hold on. Do you want to know when you should come back?
Same time everybody else, April 27th.
At what time?
1 o'clock.
9 o'clock, because you're unrepresented.
That's fine.
We'll see you then. I'm sorry, come back?
Yes, sir.
Okay. But you mumble every time you walk away from me. I suggest you don't do that next time, Mr. Pittman. Who wants to go next? Christopher Quillen.
Your Honor, this is Christopher Quillen. He's before the court on 26 CF 128 and 26 CF 138. We're going to tender not guilty pleas and request trial by jury.
All right, it's going to be April 29th, 9 o'clock for Mr. Quillen. We'll see you back on that date, sir.
She finally did call.
Herbert Rogers. All right, good afternoon, Mr. Rogers. You're here in 26 CF 82, charged with possession of a controlled substance, as well as, let me just double check. Can't see the information. Do y'all have one up there?
I have one.
Looks like one was filed today, but I don't have a copy of it. You know, print one out for Mr. Rogers.
I can, I've got it.
All right, they're going to sir, okay. They're going to print you out a copy of your charging document. Mr. Rogers.
Yes, sir.
I'm talking to you.
I'm sorry.
Okay.
I wasn't speaking.
I just want to make sure you're paying attention because I got to ask you some questions because you're not currently represented.
Absolutely.
Are you going to hire a lawyer or do you want me to appoint you one?
Is it possible to be appointed one?
It is. Can you afford to pay for an attorney?
I cannot.
I'm going to have you fill out one of these applications that the bailiff is giving you right now. Fill it out this afternoon and turn it in before you leave. But I'm going to provisionally appoint the public defender's office to represent you. They're going to have a charging document to you soon, but it's possession of controlled substance and paraphernalia.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
All right, we're going to see you back, Mr. Rogers, on April 27th at 1 o'clock. Stay in touch with Ms. Rivers. Make sure you fill out that application and turn it in before you leave. Mathis Root. All right, Mr. Root, you are here in 26 CF 176. Where you're charged with grand theft. You don't have an attorney. Do you plan to hire one?
No, sir, I need an application.
Okay, so I'll give you an application for the public defender's office. Can you afford a lawyer? I just have to ask the right questions.
Not right now.
Okay. Fill out that application. I'm going to provisionally appoint the public defender's office to represent you, Mr. Root.
We're going to enter a not guilty plea and request trial by jury.
All right, April 27th at 1 o'clock. Make sure you fill that out, turn it in on the first floor before you leave here today.
Central Florida, like in Orlando.
Your Honor, he's indicated that he lives in Central Florida. He's asked for Zoom. Would the court consider allowing him to appear by Zoom?
Whatever you decide, Ms. Rivers, I'll grant it, I'm sure, but as long as the case is progressing.
Sir. Thank you, sir.
Daniel Salisbury. All right, 26 CF 257, charge of grand theft.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
All right, Mr. Salisbury, you'll come back on April 29th at 9 o'clock for your pretrial conference. Terry Sapp. Are you Mr. Sapp? Okay, Mr. Sapp, you're here in 26 CF 139, charged with failure to register every 6 months.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
All right, April 27th, 1 o'clock is your pretrial conference. Mr. Sapp, stay in touch with Ms. Rivers. All right, Ashley Scott.
I just get a hold of you.
All right. Oh, she's here. Let's see. Has the state filed an information on Ms. Scott?
Showing that we did.
Ms. Scott, you're, let's see something.
I'm showing that we did, but is it not showing up?
I think there's paperwork missing from her file. That's what it looks like.
I can print one out, the same I did for Mr. Herbert.
That would be great.
Okay.
All right, Ms. Scott, you're charged with possession of a controlled substance, possession of paraphernalia. You don't have an attorney here to represent you. Are you going to hire one?
No.
Can you afford a lawyer?
No.
All right, I'm going to have you fill out one of those applications, and I can appoint you a public defender. Make sure you fill that out and go turn it in downstairs on the first floor.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
Scott, you'll come back April 27th at 1 o'clock for your pretrial conference. Elvin Sharp, did we handle that yesterday?
Yes, Your Honor, we did.
Okay. That was a plea yesterday. Jessica Smalling, I'm sorry.
Smalling.
Sorry about that. I
It's okay.
thought it was two I's for some reason. All right, you're here in 26 CF 166, where you're charged with petty theft and false owner on a pawned item. You don't have an attorney that's on your case. Are you going to hire one, or would you like one appointed?
One appointed, please.
Can you afford one? No. Okay. You fill out that application, bring it downstairs to the first floor clerk's office to turn in. I'm going to provisionally appoint the public defender's office to represent you.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
April 27th, 1 o'clock, Ms. Smalling. We'll see you back on that date. Stay in touch with Ms. Rivers. Scott Smith. Mr. Smith, you're here in 24 CF 452.
Your Honor, I believe we've reached a resolution in this matter. I just need for my client to sign the agreement.
this a downward departure?
Yes, it's a downward departure based on a negotiated plea bargain with the state.
All right, Mr. Smith, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Scott Michael Smith, 8/24/1979.
All right, and Mr. Smith, you're here on possession of controlled substance, third-degree felony punishable by up to 5 years in prison, and possession of narcotic equipment, first-degree misdemeanor punishable by up to a year in county jail. Do you understand that? I've been handed a plea and sentencing agreement that would call for you to plea as charged, an adjudication of guilt, so it's a felony conviction, 6 months county jail, credit for time served, $6.15 court costs, $100 PD fee, $50 application fee. I would give you 90 days from your release to pay those or set up a payment plan so you don't have a civil lien.
Yes, sir.
Is that what you want to do here today? Did you go over this agreement with your lawyer? Did you understand and sign the agreement? Are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've read? You understand that by entering a plea there won't be a trial of any kind. And you understand that you're giving up your trial rights, which are on page 1, going on to page 2 of that agreement that you've signed. And you understand if you're not a U.S. citizen, this could lead to your deportation. All right, what is your plea to the possession of controlled substance and the narcotic equipment?
No contest, sir.
I'll accept your no contest plea as freely, voluntarily knowingly given, adjudicate you guilty, 6 months jail, credit for time served, $6.15 court costs, $100 PD fee, $50 application fee. I'll give you 90 days from your release to pay those or set up a payment plan. I do need your fingerprints, Mr. Smith, because it's a felony conviction. You have 30 days to appeal. This is a downward departure as announced by the state for uncoerced plea bargain. You did score 35.5 months.
Thank you, sir.
So, something to keep in mind. Thank you, Mr. Smith.
If we could hold him and put him in the interview room. Thank you.
Chris Varner.
Mr. Ron. Hello, Mr. Varner.
I think we've had a female Varner a few times, too.
Hello there.
Yeah, that's exactly what I'm talking about.
Your Honor, this is Mr. Varner. He's on 26 CF 97. He's charged with the aggravated battery of using a deadly weapon and tampering. Your Honor, well, actually, tampering with evidence. They did charge it as that. Your Honor, we're going to enter not guilty plea and request trial by jury, and we'll ask for the 4/29/26 court date.
All right, April 29th at 9 o'clock, Mr. Varner. We'll see you back on that day.
I'll come back out to see you in a couple of weeks, okay?
right. All right, Ronnie Watts. Maitland White is on this afternoon. The one that sat here all morning. All righty, Ms. Watts. Okay, Ms. Watts, you're here in 26 CF 183, where you're charged with possession of a controlled substance. Do you understand that?
Yes, sir.
All right, you don't have an attorney. Are you going to hire one, or would you like one appointed?
I need one.
Okay. So would you like one appointed?
Yes, sir.
Okay, I'm going to have you fill out this application that the deputy's handing you.
Thank you.
I'll provisionally appoint the public defender's office to represent you, but you have to fill out that application, bring it downstairs to the first floor, and turn it into the clerk's office.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
All right, April 27th at 1 o'clock, Ms. Watts. We'll see you back on that date. Stay in touch with Ms. Rivers. You're welcome. Miss, let's see, Wayne Willis. Come on up, sir. All All right, afternoon, Mr. Willis. I think you've been here the longest and you get called last. How's that work? All right, Mr. Willis, 26 CF 243, charged with failure to register a cell phone number or telephone number.
Excuse me, Your Honor?
It's the vehicle, Your Honor.
Mine says cell phone number.
So does the paper that I signed when I paid the $50.
Hold on. I'll see what the information says.
And that was filed this morning, Your Honor.
All right, information was filed, says failure to report in person to the sheriff's office within 48 hours after any change in vehicles owned. Third degree felony, level 7.
The other meet to go over, okay? All right, we're going to enter not guilty plea, request trial by jury.
All right, Mr. Willis, we'll see you back on 4/27th, April 27th at 1 o'clock.
See about this.
Stay in touch with Miss Rivers. And our last inmate should be Ashley Woody. Can you handle her?
We did handle her the other day, yesterday, Your Honor.
She's done. Did we resolve
She's
this
not
case?
done. She's not done. No, Your Honor. This is a case where RCC and I both represent her, and based on some new information, it is a conflict for us to continue to represent her on 26 CF 200. And at this time, we're making an oral motion to be relieved and to appoint regional conflict counsel. I do believe they have reached a resolution.
All right. I'll grant the motion to withdraw, appoint RCC. Mr. Kleins.
Your Honor, after exhaustive pretrial work, we're ready to resolve everything. So, at this time.
Definitely exhausted, but go ahead.
Yes, that's true. At this time, in 24 CF 2724 and 26 CF 200, Ms. Woody will withdraw her previously entered not guilty plea. Actually, I don't think she's ever entered a plea in the 200 case. She's going to be entering a no contest plea as charged in those two cases. She's also going to be entering a plea to 26 MM 197. That is one count of possession of paraphernalia. The agreed upon disposition on the misdemeanor case, Ms. Woody will be sentenced to time served. I believe it's $270 in court costs, a $50 application fee, a $50 cost of defense. In 26 CF 200, there are two counts. Count 1 is possession of controlled substance. Count 2 is possession of paraphernalia. On count 2, in the 200 case, Ms. Woody would be sentenced to time served. On count 1, Ms. Woody would be placed on 3 years of supervision. As a special condition of the supervision in the 200 case, she will submit to a substance abuse evaluation and any recommended follow-up treatment. She will be assessed $615 in court costs for that case and a $100 cost of defense. In 24 CF 2724, that's a grand theft case, Ms. Woody will enter a no contest plea. She will be sentenced to 3 years of probation concurrent to the probation imposed for the 200 case. The court will reserve jurisdiction for 90 days to determine the appropriate restitution. In the 24 CF case, she would be assessed $615 in court costs, another $100 cost of defense. She's previously been adjudicated. She will be adjudicated. Just so the court's aware, I've already talked to probation. I believe that Ms. Woody has a hold from Santa Rosa County. There's a misdemeanor case over there. She failed to appear because she was in custody over here. So I have already advised probation and Ms. Woody, essentially, especially Ms. Woody, the instant she's wearing street clothes, she needs to report to probation. But I've already talked to probation and said, look, double check her whereabouts because I don't think she's getting out today. If I may approach?
All right, thank you. Yes. All right, Ms. Woody, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, can you state your full name and date of birth, please?
Ashley Barbara Ann Woody, April 16th, 1991.
Okay. You heard what your attorneys announced, but quickly, 26 CF 200 is possession of controlled substance and paraphernalia. 26 MM 197 is possession of paraphernalia. 24 CF 2724 is grand theft. That's a third-degree felony. Have you gone over this plea and sentencing agreement with your lawyer?
Yes.
Did you have enough time to do that?
Yes.
Okay, and did you understand and sign it?
Yes, sir.
Is that what you want to do here
Yes, sir.
today? Your attorney's already announced all the terms, so I'm not going
Yes.
to do that again until I actually pronounce your sentence. Did you have any questions about the terms?
No, sir.
Are you satisfied with your attorney's advice and representation?
Absolutely. Yes, I
are you
really
cur-
appreciate it.
Okay. Are you currently under the influence of any
No,
alcohol, drugs, or
absolutely
control?
not.
Miss Woody, slow down. I've got to say everything, no matter if you respond in the middle of it or at the end of it. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement announced by your attorney and written on this paper?
No, sir.
And do you understand that if you enter this plea, there won't be a trial of any kind?
Yes, sir.
And do you understand you're giving up your trial rights, which are on page 1 and 2 of the agreement you've signed?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. What are your pleas to the possession of controlled substance, 2 counts of paraphernalia, and the grand theft?
No contest.
All right, accept your no contest plea is freely, voluntarily, knowingly given, and 26 MM 197, time served, 270 court costs, $50 application fee, $50 cost of defense. It's an adjudication of guilt on all counts, all cases, and 26 CF 200. Count 2 is going to be time served. Count 1 is 3 years of probation, substance abuse evaluation, any recommended treatment, 615 court costs, $100 cost of defense. 24 CF 2724 is also going to be 3 years probation concurrent with the 200 case. Reserve jurisdiction for 90 days to determine appropriate restitution value. 615 court costs, is that right?
615?
615 on a grand theft. That would be 550. 615 is usually drug cases.
If it's,
It might be less, is what I'm
I was
saying.
gonna say,
I
if
would
if I
really
wrote
hope
too
so,
much.
because I'm trying to
by
get
all
it paid
means.
off really quickly.
Also, $100 cost of defense.
Ms. Woody would just request, and I've talked to probation about this, if we can roll the court costs from the misdemeanor case into her probation supervision so she has time to pay that.
Okay. She can pay her 26 MM 197 court costs through probation on her other cases. That's what you're saying?
Yes, sir.
Mr. Berry?
That's no problem with us. She ain't gonna pay it anyway.
She's gonna try.
I know Miss Woody.
Okay.
How many can you, Mr.
She's going
Berry?
to try her best this time, Mr. Berry. All right. So
I
she
got
can pay all of her
$7,000
costs
in it.
through her probation. All right. This is a guideline sentence. She scored 38 points. Anything that I've missed?
No, Your Honor, I don't think so.
Okay. All right, Miss Woody, I need you to speak with probation, who's
I
sitting
did
there
2 years
behind
community
you.
control with that man. He'll make sure I don't violate.
Supervision fees are waived due to the fact you've been found indigent. After you're done with probation, I need your fingerprints, and then you have 30 days to appeal.
Okay.
All right, I think that's the end of our.
Judge, Mr. Mason, Ashley Mason, if we can go ahead and call him back, I can go ahead and take care of him, and the jail can take him back.
All right. He's just the plea, right?
Yes, sir.
Is he ready?
Yeah, I'm fine. Yeah, that's fine. Should be, yeah. Rayon black, Ms. Flowers? Okay.
Judge, this is Mr. Ashley Mason, 26 CF 109.
All right, Mr. Mason, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name and date of birth, please?
Ashley Lamar Mason, 4/13 of 1980.
All right, and Mr. Mason, you're here charged with possession of controlled substance, third-degree felony, punishable by up to 5 years in state prison, and paraphernalia, first-degree misdemeanor, punishable by up to a year in county jail. Do you understand that?
Yes, I do.
I've got a plea and sentencing agreement here that calls for you to plea as charged, adjudication of guilt, so that's a felony conviction, 90 days credit, 90 days jail with credit for time served, 615 court costs, 150 PD fees. Give you 90 days from your release to pay those and/or set up a payment plan. I do need him to sign it, though.
Suggest we trade
temporarily.
That's another copy.
Okay.
On it while you're
Oh, I see
going
what you're
through the
saying.
rest of it.
All right, Mr. Mason, did you understand that agreement, and are you now signing it?
Yes, I am, and yes, I do, Your Honor.
Okay, do you need more time to speak with your lawyer about it?
No, sir, Your Honor.
Are you satisfied with his representation and advice in this case?
More than satisfied.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir, they have not.
Thank you, Mr. Williams. Has anyone promised you anything other than the terms of the agreement I've announced?
No, sir.
Do you understand if you enter this plea, there won't be a trial of any kind?
Yes, sir, I do.
Do you understand that you're giving up your trial rights that are in the agreement that you signed?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
What is your plea as charged?
No contest.
No contest, Your Honor.
Accept your no contest plea is freely, voluntarily, knowingly given, adjudicate you guilty, sentence you to 90 days with credit for time served, concurrent between the two counts, 615 court costs, 150 PD fee. I'll give you 90 days from the day that you're released to set up that payment plan or pay it off. This is a guideline sentence. You scored 36 points. I'm sorry. 28.6 points. All right, I just need your fingerprints when they're done, Mr. Mason.
Thank you, Your
30
Honor.
days to appeal.
Thank you, Judge.
Who else did you have? Beck? That was
Take any of the above.
David Beck.
Misdemeanor petty theft, credit for time served, 270 court costs. Charge, you already that. Date it for me here, sir. Close.
Yeah.
Not 2022. All right. Now approach, Your Honor.
Yeah. All right, Mr. Beck, raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
David Michael Beck, 7/24/92.
All right, Mr. Beck, you're here in 26 CF 149 where you're charged with felony petty theft, third-degree felony, punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that calls for you to plead to a lesser-included misdemeanor petty theft. Is that a first-degree misdemeanor then?
Yes, Your Honor.
First-degree misdemeanor, 812014, paragraph 3B1. In return for your plea, be credit for time served, 270 court costs, $100 cost of defense, and adjudication of guilt. I'd give you 90 days from your release to go ahead and pay those costs or set up a payment plan. Is that what you want to do, Mr. Beck?
Yes, sir.
Did you go over this form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Definitely.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Anyone force, pressure, or threaten you to enter this plea?
No, sir.
Anyone promise you anything other than the terms of the agreement I previously read?
No, sir.
You understand by entering this plea, there won't be a trial of any kind?
Yes, sir.
You understand you're waiving your trial rights, which are on page 2 of that document that you've signed?
Yes, sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, what is your plea to the misdemeanor petty theft?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, credit for time served, 270 court costs, $100 cost of defense, adjudication of guilt. I will need your fingerprints because it's an enhanceable offense. And you have 30 days to appeal the judgment and sentence of the court.
All right, thank you, Your Honor.
All right,
Thank
thank you.
Good luck,
There you
man.
go.
Yep.
Thank you.
Yeah, that's all I have. If I could be excused, thank you.
Sure you don't want to stick around?
I've got things to do, Your Honor. Thank you.
Oh. Unreal. All right, who's next?
I have Christopher Dredding, I believe, is on this morning's docket and got pushed to this afternoon.
Oh, yeah, that's right.
I'm covering this case for attorney Chris Crawford.
Your name for the record.
Dustin Harsher.
All right, so that was from this morning. Let me pull back to that. All right, what are we doing with Mr. Drain? Is he in custody? What are we doing with Mr. Drain today?
Your Honor, I believe we have an agreement. I'm not sure how the court wants to enter it, if it's going to be as like a plea agreement, but we're going to be entering an admission to the violation of community control. And I believe
a signed agreement?
I have an agreement. I haven't gone over it with, I mean, I've drawn it up in court today,
Okay.
but
Do
the
you
terms
want
have
to meet
been
with him real quick
discussed.
to go over it? I can put him in one of the side rooms and you can talk to him for a few minutes. I'll call you right back up as soon as you finish.
That could work.
Okay.
Thank
Sorry,
you,
Mr.
Your Honor.
Harsher, I would have told you that earlier if I known that was the situation, but we'll
It's
call
all
you
good,
back
Your
as
Honor. I
soon.
just appreciate you putting us off this
Oh.
afternoon.
I'm here all day.
Thank you, Jeff.
Come on up. All right. I'm sorry, I always have to look up Miss Del Bosque. Sorry, it's going to take me a while.
Represent Tremaine Parker, Your Honor.
Okay, Mr. Parker. Do we have Mr. Parker? Do we have any other private counsel? I think that's it.
Your Honor, we're going to orally withdraw our motion.
That was a bond motion, right?
No, we did the bond motion. This
Oh,
was a
did we?
motion to dismiss,
Okay,
basically
yeah.
a hearing. Your Honor, at this time, Mr. Parker would like to admit to the technical violation. I don't have an agreement with the state on anything, so we'd like you to hear argument on it.
On sentencing today? That's not normally the way I would do things, just because
Okay.
I don't know enough about your client. Or y'all want to go forward on sentencing today?
I'll leave it up to the court, Your Honor. For me, I do have witnesses who I would like to have them testify for sentencing purposes. I can ask if the court would like to postpone it.
When would the next available date be, Your Honor?
We could do it next week, right?
Um,
You have March 5th?
Yes. But I would ask if it's possible, Your Honor, that my witnesses at least appear via Zoom because would that be okay?
I have no objection to Zoom.
Okay.
Can we approach for a second?
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years.
All right. So,
Come in
Mr.
and
Parker,
let us
I'm going to
take care of
special set your sentencing is going to be for March 6th. It's not special set in the fact that we don't have a docket already. It's just not a date. We would normally put something like this, but we do have some availability, so I'll put it on March 6th at 9 a.m.
Your Honor, may I ask that he enters his admission
Enters
for...
the plea first. Right now.
Oh, you don't want to accept
No,
the admission
yeah,
now?
I can do that. Is that what y'all want to do?
Yeah, we can
Okay.
do that, admit the violation.
All right. Mr. Parker, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you're here on a violation of probation, correct? All right, and you had a motion to dismiss that was filed, but you're withdrawing that at this time? Okay. So you have a right to have an evidentiary hearing, which means that a right to have a hearing where the state would have to prove by a preponderance of the evidence that you violated your probation in some way. You understand by entering a plea, you'd be giving up that right. All right, now there isn't an agreement as to what your sentence will be. Do you understand that? All right. And what is his exposure?
There's a new score sheet, Your Honor, if I may approach with
Yes,
it.
if I can see that.
It was corrected. The last
Full exposure is 20 years. Is charged with a second-degree felony and a first.
A second and a third, okay. All right, so you understand your maximum sentence could be as much as 20 years in state prison? And do you understand that your lowest permissible prison sentence in months is 20.55 months? Okay, now your attorney can try to argue for a downward departure, but it's on you to prove that one of those, number one, applies, and two, that I should give that downward departure to you to get less than that. Do you understand that?
Yes, sir.
All right, and how much credit do y'all think he has in?
Oh, no. Close to 9 months, Your Honor.
Total from the entirety of the case? Okay. So I just want to make sure, I mean, if you had done some time on this or something, then it might change things. But, all right, so 20.55 months. Obviously, you get credit for any time that you serve before now and going up until your date next week. All right, have you had enough time to discuss this with your lawyer?
Sir.
Are you satisfied with your lawyer's representation and advice up to this point? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in order to plea? No. And do you understand that you're waiving any potential defenses that you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, so what is your plea to the violation of probation?
Guilty.
Are you admitting or denying the violation?
I admit it.
That's fine. I'll accept your admission as freely, voluntarily, knowingly given. We're going to set you on March 6th at 9 a.m. for purposes of sentencing. If anyone's going to file anything you want me to read, please do it before, certainly no later than noon Thursday, the day before, so that way I can take a look at it in advance.
All right,
Yes, Your Honor, thank you.
That's all I have. May I be excused?
Yes. Can I give this back to you so you guys can give it to me then? Otherwise, it's going to get lost in the shuffle. Because I don't want to fill it out because it's not done yet. All right. Thank you, Mr. Parker. We'll see you next week.
Not yet, but.
All right. Mr. Kleins or?
Your Honor, can we approach on Mr. Llewellyn?
Sure.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
I'm Wanda.
Your Honor, I've talked to Mr. Llewellyn. He just was requesting the court to consider removing the GPS monitor. I know what we just discussed at the bench is transferring this to Division 2. So I just, on his behalf, I need to request the court to consider removing the GPS monitor. We are not asking to transfer this out of any desire. I mean, I want the case to resolve.
I understand.
So, but
I have to go back and remember what the issue was on the bond.
It was, I know it was a February 2025 appearance. I don't know the date off the top of my head.
And is there, I don't really recall it, but I'm looking up the paperwork. It says that the state had stipulated to have it removed for purposes of a procedure, I believe, Mr. Llewellyn, but I had denied the reason for it to be removed long-term. State have a position?
State objects.
What's the nature of the objection, just so I understand?
I could bring the victim up here. I believe the victim would not want a change in the bond condition.
Only thing I could point out, Your Honor, is as far as I'm aware, and I'm pretty sure I would be made aware if this was not the case, I don't think there's been any issues while he's been out on bond. He has been out on bond since October. So he has been on a monitor since his release 16 months ago, whatever it is. I'm unaware of there being any issues. He lives in Walton County. He doesn't even live in Okaloosa.
Excuse me. My objection would also be notice.
I mean, it's still the same judicial circuit, but.
I didn't mean to interrupt. The objection would also be notice. I wasn't notified of.
And that's, I mean.
Part of the reason I asked.
I know.
All right. Y'all have asked to have it transferred. I'll let the new judge make that decision. I've already made it previously. I don't have any recollection of it, Mr. Llewellyn. That was a year ago, and I've literally handled thousands of cases since then. So I can't say I remember it specifically, and this is why I turned it down. I just don't recall it.
I have surgery January 10th of last
year. January 10th.
This court has previously, I mean, obviously, Your Honor just said it, has previously said, if there's a procedure coming up, let me know the details. Mr. Llewellyn did advise me that he does have a procedure coming up at the end of March. I have told him, give me the details, and I don't think there would be, I mean, if something has to come off.
I think the state stipulated to its removal
Right.
for
I
purposes
just
of a
need the
procedure
details.
last time.
Right. And we would maintain that stipulation because, it's got to come off.
Especially for the procedure that was being done last time, it would be dangerous. But if that's the case, you can certainly bring it up.
Dangerous for me now. It has been.
All right. I'm doing what's been asked of me, Mr. Llewellyn. I'm transferring the case.
And I will present an order to the court tomorrow. I'll try to get it to you tomorrow, Your Honor, although I am writing motion to suppress in the morning. So, but I definitely, we'll get this back in front of Judge Stone, and we'll reset the hearing as quick as we can.
What I'm going to do, because I don't know Judge Stone's dates as to what you want to put it, I'm just going to keep it on mine for status purposes, April 27th at 9 o'clock. Once it gets transferred, you'll get a new date, Mr. Llewellyn. I just don't know Judge Stone's calendar well enough to tell you which date it should go on. Once
I'm
it gets
fairly certain that Judge Stone has a cycle starting on March 9th. So, yes. I'll double check.
We have the
with Mr.
same
Wood.
type of cycle of court dates. They're just offset. So I don't know when his are, but that sounds probably right. All right, give me the order. I'll get it signed as soon as it gets to me.
Yes, sir. All right, James.
All right, thank you, Mr. Llewellyn. Mr. Sprout, are y'all expecting any other witnesses on Zoom for anything?
Yes, Judge. We've got a bond hearing on Mr. Hoover, and this is the one where the wife is asking to be able to have contact.
Okay.
We're not asking for contact with the child, just.
Okay. Is that Sabrina?
I believe, Judge, I'd have to pull it up. Your wife's name, what's her first name? Sabrina?
Yeah, okay, she's on the Zoom, I can see. All right, Mr. Harsher, did you want to finish out yours?
Yes, Judge.
Can we get Mr. Redding?
He's in agreement with what we've reached with the state. However, he did bring up a very good point that once he is released from jail, he's not going to have an address. I believe his living situation is no longer something that he can go back to.
Okay.
So he was going to see if there was any way that there was some kind of halfway house or some kind of equivalent that he could be released to upon release. I'm not sure.
I don't know.
I thought that was smart that he brought that up, though, because he's got to give an address to probation.
Is he going to be on probation?
Yes, it's a reinstatement, Judge.
Wasn't he from Escambia County? I remember that part of it.
Yes, sir.
But I just don't remember anything really much more than that. So where's the plan to go?
Escambia County, sir.
What would have to happen is, I don't have an issue with that, but probation's going to talk to you about it, and they can transfer you to the Escambia office, because it's still in Florida, it's still in this circuit.
Yes, sir.
But you're going to have some sort of address, but I don't have a halfway house to send you. Those are usually DOC type programs when you're leaving prison, not the county jail. So, and that's not handled by the court. I mean, I'm not trying to dodge it. I just don't know.
Yes, sir. I was just trying to be honest with the situation, sir. I literally just found out 3 days ago myself.
Mr. Berry, do you have a?
Your Honor, I believe it's a sex offense.
Yes,
Is that correct?
yes, sir.
Yes, sir. There is called the REAP House over in Escambia County.
REAP?
REAP. I don't know what it stands for.
I used to.
But we don't mind for Mr. Redding reaching out to the REAP house to see if they have beds available for him.
Sir, and they said at the moment the two houses available, they do not have bed space.
Reentry Alliance Pensacola.
That is the place that we have afforded to us.
I guess the concern is until that becomes available, what's the situation?
Situation is he wouldn't have an address to report to probation once he would be released. He's still got to wait to get hooked up on a monitor. I think that would take like 24 hours at tops.
And then he's going to have his registration requirements too. Oof.
Yeah.
What is the negotiated plea?
Would be 30 days county jail. He's been in 50 since January 9th, with credit for time served and reinstatement to the original terms of probation.
I'm just a little concerned as to putting him in a situation where he's likely to be violated, even if he's not trying to violate.
That's what I'm trying to avoid, sir.
Well, but unfortunately, I'm not the one that really makes that decision. And all I can do is give you the rules, but I can't tell you how you should play the game. And let me rephrase that because it makes it sound like this is a game. It's not a game. I'm just trying to use the analogy of rules. I can't tell you how you should play within those rules, just what the rules are.
I know you don't want to stay in jail any longer.
I mean, I'll get it figured out. I was just hoping maybe, you know what I'm saying?
I mean, probation is going to work with you the best they can, but as you can see, their one suggestion and you've already looked into, so they may become available at some point, but I just don't know.
Do you still want to do this today, knowing
Yes, sir,
that
man.
risk? Okay.
That's fine.
Homelessness in and by itself is not a violation of supervision.
But it's just, you got to really play by those rules really well. And to,
Correct. He will be required until he finds a stable residence to report to the probation office daily. He will speak to his probation officer, and they will try to work with him on how we can get him I hate to make it sound like it. We can get him a homeless kit.
Yeah.
Meaning a bed, a sleeping bag, you know, those type things. Tent.
Yeah.
Can't tell him where to put it. We can tell him where he can't put it.
Yeah. Well, because it's the SO requirements too, right?
Right. So we can tell him, if he came to us and says, hey, I want to put it here, we'll run the program and say, okay, that fits the criteria. If it doesn't, we'll say, oh, you can't put it there.
But you're also talking about being a Escambia County, so it's not going to be you, Mr. Berry, or someone in your office. It's going to be someone over there once he's transferring over.
That would be correct. But we can't transfer him over there as homeless. Not saying he can't go to REAP, but we can't send him over there to live at quote unquote the park over there. He would have to stay.
Until he has an address over there.
Or through the REAP program. If he's telling us right now, I don't have one, our first contact will be to that REAP program, if he's willing to go.
I was just hoping maybe if worst case scenario to prevent failure, if I had to sit in jail waiting on a bed space at the program, that would be something I would have to do. I mean,
But is he going to be?
I mean, it's
What probation does he have?
2031.
I mean, I guess I don't know what to do if it's, we can say REAP as part of his probation.
That's what I was
As far as
trying
the bed
to-
situation, Mr. Berry?
Orders at bar's bed, that's how we'll see about it.
That's honestly what I was asking you to do, sir.
I'm just not familiar with the program that you're talking about, the REAP program, as far as how long it takes, and is this a situation where I can require he do it, as opposed to what he's really asking for is, I'd like to do this. Because, what if he gets told to leave for whatever reason? Now has he violated his probation as opposed to just doesn't
Right.
get to live there anymore if I make it a condition of his probation.
Not only this, Your Honor, if I may, we don't know at this time if they have a bed available, so if they never have a bed, then he's gonna sit in jail.
Well, unfortunately, that does happen with all sorts of different programs we send people to. Real problem in juvenile system where I've had kids sit there for months waiting for the programs.
No, I realize that if I may, Your Honor, normally though.
Mr. Berry might have something else.
Your Honor, just received a text from our officers who would be supervising him, and he says, REAP is not a treatment, it's a halfway house.
Yeah. Well, that's what I'm saying. I want to order it because it's not a program.
Right.
But if they decide, you know what, it's not working out, Mr. Dreddy, we're going to have to ask you to leave, is it a violation of probation now? If I've ordered it, that's what I'm trying to avoid.
I mean, my question is, what do I do for an address? I signed this deal today. They come up to me tomorrow. What address do I give them?
Sir, we'll work with you, but we can't work with you while you're in jail. As soon as you walk to and get put out on our front doorstep, so to speak, then we will try to assist you the best that we can. Once again, we can tell you where not to go.
Yes.
We can't tell you where to.
Understood.
Based on that, what would y'all like to do?
I'm just going to have to come out of pocket.
Yeah, and then figure it out.
I got some money put up. I'll have to come out. Yes, sir. All right. I'm just going to.
Does the court require a formal plea agreement to be signed and everything?
That would help.
Okay.
Just so it's clear, especially given what we're talking about.
I'll put in it's 226. 26.
Your Honor, if I may, they just text me back. Officer Roberts says he will be shown the map of suitable locations around this area, and he will select one. And then that's where we'll supervise. Once again, homelessness in and by itself is not a violation.
Of course, but it just makes the rules a little bit more strict as far as the personal meetings or daily meetings, right?
Be required to see him a little more.
So that means that my probation will be transferred from Pensacola to Okaloosa now.
Are you on probation there too?
My probation's been at Scambia this whole time.
Well, you're here for a VOP, right?
Yes, sir, because the original charge originated here.
He's on probation out of this county.
You're on probation from here, and it's
Okay,
been
okay,
in
okay.
Escambia. You've been supervised in Escambia. this
Okay,
entire
okay, I
time,
understand
But the case
now.
is from here.
But at that point, he had residence over in those camps. We can't just dump homelessness to another.
Understood. But once you get a place that you can talk to them
I
about
can
going
transfer
over
it
there.
back because I got kids
As long as
over
it's
there, that's the only
inside
reason
Florida, it's pretty easy. It's once you
Okay.
start trying to go over a state border that causes a problem.
Yes, sir, I understand now.
Yes, we'll give him an opportunity to go over into Escambia County to seek housing.
Sure.
He just has to live in Okaloosa until he finds something.
Okay, that's not an issue.
Okay. Mr. Roach? You guys have guidelines? All right, so this is going to be a downward departure? I'm assuming?
This is a downward departure for a negotiated plea agreement.
Is it part of the issue too that he served a significant amount of time for a case over there?
Yeah, and I think he received time served as a resolution for that, but they contemplated to include this as part of the resolution.
That's how I remember. So basically, he served the time he would have if it had just been consolidated all together.
Yes, Your Honor.
Yes, yes.
Okay. This is somewhat academic at this point. All right, Mr. Drenning, can you raise your right hand? Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Sir,
All right, can you tell me your full name and date of birth, please?
Christopher Allen Dreading, 12/7/1987.
All right, and you're here in 17 CF 1162 on a violation of probation. have been handed a plea agreement that calls for you to admit your violation of probation, be adjudicated guilty, 30 days in the county jail, credit for time served, reinstate your original terms of probation. It'd be a $100 VOP fee, right?
Thank you.
Yes, sir.
Is that what you want to do today, Mr. Dredding?
Yes, sir.
All right, and did you have enough time to go over this with your attorney?
Completely, yes, sir.
Okay, and we've discussed a lot of different options here, but you understand that, you know, the rules are going to be what they are, and you're going to have to do your best to work with probation to make sure they work.
Yes, sir.
Okay. And are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter the plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement you've signed? And do you understand you'd be waiving any potential defenses to this violation of probation?
Sir.
And do you understand that if you're not a U.S. citizen, you could be deported or excluded from the country?
Sir.
Based on this. All right, and what is your plea to the violation of probation? Are you admitting or denying it? I'll accept your admission as freely, voluntarily, knowingly given, as agreed upon between the parties, be adjudication of guilt, 30 days county jail, credit for time served, reinstate you to your original terms of your probation. Is a departure in theory, right? Because it's only 30 days, but he scores more than that.
Yes.
Okay, but even though he served quite a bit of time on this case, he probably would, if that were computed, he'd have credit for more than he scores, right?
I'm not, yes.
Okay. All right, so, Mr. Dredding, you have 30 days to appeal the judgment and sentence of the court. If I didn't say so, the $100 VOP fee will just be tacked on with your probation. And make sure you talk to probation a little bit more before you leave this morning.
Yes, sir.
Good luck with everything.
Yes, sir.
Your Honor,
You have the
I
office's
believe Mr.
number?
Dredding was on GPS.
Oh, he has
Yes.
to have a GPS monitor before he leaves the jail.
Yes, Your
Yes,
Honor.
sir. Yes, sir.
Thank you, Your Honor.
That may delay things at least today, Mr.
It
He's aware of
may
that.
not be today, but it'll be tomorrow.
Well, I'm not going to say it'll end up being better, but it kind of puts them out during the middle of the day tomorrow as opposed to when everything's closed already.
Thank you, Your Honor. That's
All
all
right,
I
thank you,
have.
Mr. Harsher.
I appreciate it.
You're welcome. All right. Who's ready with what?
Got a quick bond motion, Your Honor, if I may.
Okay. Well, do we want to handle, Mr. Williams, are you ready to handle your bond motion since I've got someone here and I've got someone on Zoom?
I
am,
fine,
Judge.
Your Honor. That's fine.
All
Go
right,
ahead.
let's just handle that one quickly to get it out of the, I can turn the Zoom off. It's gonna be loud again.
You are in the meeting now.
Gotta be a way to fix that. All right, go ahead and call your case, Mr. Williams.
Yes, sir, Judge. This is State of Florida versus Tony Hoover. We're here for a modification of conditions of bond from no contact to no violent contact with regard to Sabrina Hoover, one of the alleged victims in the case.
She's still connecting to audio, so give me a second. Oh, it just keeps kind of going on and off. All right, ma'am, can you hear me okay on Zoom? Ma'am, can you hear me on Zoom?
Ma'am, can you take yourself off mute?
No, she's not muted, but she's not responding either. Ma'am, can you hear me on Zoom?
Turn your volume up.
I just sent her a message asking if she can hear me and to turn up her volume. It says connecting to audio again. There it is. Can you hear me now, ma'am? All right.
Yes, sorry.
All right, I think we're good. All right, go ahead, Mr. Williams.
All right, so, Judge, this is State of Florida versus Tony Hoover. We're here for a motion to modify the bond to allow nonviolent contact between the defendant and his wife Sabrina, who's one of the alleged victims in the case. She's previously provided a statement that was attached, I believe, to the motion. That statement did not directly address the contact issue. Ma'am, if I can get you to state your name for the record.
Well, hold on, let me swear her in if you're going to take her testimony now. All right, ma'am, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, go ahead with your questioning.
All right, ma'am, you contacted our office about wanting to change the bond in the case to allow you and Tony to have contact, nonviolent contact. Is that correct?
Yes, sir.
And where are you residing now?
In Michigan.
Saginaw?
Yes, sir.
All righty. And now, you and I have talked on the phone a couple of times. My understanding is that you're not asking for contact on behalf of your daughter as yet, just contact with regard to you. Is that correct?
Yes, sir.
Can you?
There is something that I would like to say, though, if I could.
I don't have a problem with that, ma'am. Go ahead.
I was just going to say that she is aware of what's going on, and she has stated that she is not wanting full contact, but she did mention something about possibly modifying it to where they could do letters if she was wanting to.
All right. Does the state have any objection to the court considering that?
Yes, I object.
Well, considering it, going ahead instead of me filing a separate motion on it.
Your Honor, I'm going to object, and my reasons.
Well,
I mean, there is one thing that I want to mention. The no contact is from the defendant to the victim. If the child victim wishes to send a letter to their father, she can do so without violating anything.
May I ask
So-
a question?
Can't respond. Talk to your lawyer, sir.
May I ask?
Well, it wasn't in the motion, and from what I just heard is she might feel that way. Doesn't sound like there was a request for it at this point.
All right, Judge.
But again, I think Ms. Leone from the state is right. There's nothing that prevents the child from sending anything to him. It's just he can't respond to it, and he can't send anything else to her.
I think ultimately, and we're not requesting it yet, but what ultimately we're going to be shooting for is that there's going to be a point in the therapeutic process for the daughter where they'll want to start having
Joint therapy sessions.
You know, we will address that when the time comes, and we're advised so by.
Usually the therapist, and I can tell you I was in family law and dependency divisions before this one, usually the therapist says, I think now is a good time for them to start having joint sessions with the therapist.
And that's why we didn't request it yet in the bond, Judge.
But ultimately, if that happens, and the state agrees to it, or if they don't, we can have another hearing. But
Yes.
These things can be done relatively quickly, but I don't like doing things where, in fact, there's some case law that talks about this. It says I can't give anyone else kind of my authority by saying, you can do this once the counselor says it's okay. I'm supposed to make the determination once it's okay or not okay.
Yes, sir. I'm aware of that. I'm not asking the court to do that.
I'm somewhat explaining it to your client as well. But.
Yes, sir. All right, so Ms. Hoover, what kind of contact are you talking about and for what purposes?
Nonviolent, for sure. And the fact that I just had a baby a month ago, and I'm sure he would like to see her at some point. And I just feel within the last 3 months, with the no contact, I've had a lot of time to think about everything, and I would like to move forward.
All right, ma'am, is there issues with regarding to maintaining the household, making decisions with regard to general parenting issues, not involving a need for direct contact between him and the daughter that's the subject of the bond condition. Are you guys, do y'all need to have contact in order to maintain these things?
Yes.
Okay. Are you afraid of him at all?
No, sir.
Do you feel threatened or coerced at all into requesting this?
No, sir. We haven't spoken, so this is all just clear mind of my own.
All right. And did you send in a statement addressing just generally what had been going on, or and what you were wanting to see in general in terms of an outcome of the case?
Yes, sir.
Okay. And was that a letter, one page bleeding on to a second page dated January 14th or so?
Yes, sir.
Okay.
I had it notarized as well.
Did you want the court to consider that?
Absolutely.
Okay. All right. Ma'am, is there any restrictions that you want the judge to put on Mr. Hoover in terms of that contact other than no acts or threats of violence?
No, I don't think so.
Is he residing with you currently up there in Michigan?
No.
Okay. All right, Judge, I don't have anything further.
I'd like to add
So you have an attorney,
you're
sir.
You're not called to take the stand yet.
I'm so sorry.
Okay?
I'm sorry.
No, Your Honor, I don't have any
Okay.
questions
Okay.
for.
No other questions for Ms.
All right. Mr. Hoover, is there anything that you want to make the court aware of?
Mr. Williams?
Yes.
Can you have your client raise his
Oh,
right
I'm
hand,
sorry.
please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
All right, Mr. Hoover, what do you want to make the court aware of?
I apologize on behalf of my original statement, but I just wanted to make this statement that I've been seeking counseling. I've been actively seeking. I went to a therapist as well. They have prescribed something as well in the situation, and I have been going consistently to therapy. One of the concerns, the only reason I was asking about the letter thing, is one of the concerns that they had with the therapy is it's almost impossible to find somebody that is certified in Michigan and in Florida. So in order to do a joint therapy session, the contact would have to be modified before they could request it, is what I was being told. Now, do I know that that's the case or not? No, but that is what was being talked about with me and my therapist.
Basically, are they explaining to you that if the therapist is licensed in Michigan, they can handle issues with your daughter and with Sabrina, but they wouldn't be licensed to handle issues with you here in Florida?
Or vice versa.
Or vice versa.
Which makes it a complicated thing as far as the contact goes, and I understand the state's position on it, but I also am trying to repair things, and it's impossible to repair things with literally no contact. I'm just asking for the court's...
Is the child in counseling?
Yes, I believe so.
Has that counselor said, I think it's time for her to have contact with Dad again?
Since Sabrina's the one
Well,
that
that's my point. These are things that need to be talked about in advance. I don't know.
Well, Judge, I didn't.
She testified and no one asked her that, so.
Because we're not asking for contact with the child
Okay, then
yet.
why are we talking about it? I mean, we can have these hearings when we get to that point, but
Yes, sir.
I can't make contingency hearings that says, once someone else says it's okay, it's okay.
Right, I'm
There's
not,
case
I'm
law
not
on
asking the
point.
court
I
to do
cannot
that.
delegate my authority to make decisions in cases.
I agree, and when I was doing family law and judges would do it, it drove me nuts. So we're not asking for that. We're just giving the court the broad overview. That's all. All I'm asking for is that the two of them be able to have nonviolent contact.
So let's focus on that. She's asked for it.
Ma'am, say something.
I have no objection.
Yes, ma'am.
I was just gonna say that I'm just more concerned as of what we're here for today than as far as my daughter
I agree.
goes.
All right, so we're focusing only on contact with her, not the
Yes.
daughter. All right, anything else you want
No, Your Honor.
any other argument to be made, Mr. Williams?
Judge, just that there's no real threat here. They've been without contact for a while. There's been no allegations of any further improper conduct by Mr. Hoover. I certainly understand the state's concern. Obviously, there's a concern in these cases always, but under the circumstances, particularly with her in Michigan, him down here, allowing them to have some communication seems to be appropriate.
Yes, Your Honor. The state would not object to remote contact between the parties. The state objects to physical contact between the parties due to the nature of the charges, the fact that Child Protective Services has expressed that there is at least still fear on the side of the child victim, and I'm just afraid that...
We're not talking about
I
contact with the child.
I understand, Your Honor, but I'm afraid that by having physical contact, there may be contact with the child.
Then that would be a violation.
If we get...
Ma'am, we're past the evidentiary portion of this. This is argument.
So in other words, Your Honor, the state agrees to a remote contact, video visitation, phone, internet, whatever, but not physical.
With her?
With her, yes.
Judge, they do have another child together. How about we allow them to still have contact, face-to-face contact, but not around the adult daughter who's the...
Adult.
Well, not adult daughter, but older daughter. There's a newborn as well, Judge. Not around the older daughter that's the subject of the other count.
This is what I'm going to do. I'm going to grant the motion to this effect. He can have contact with the wife, Miss Sabrina, nonviolent contact. He still can't have contact with the daughter. That's the victim, alleged victim in the case. I don't have an issue with it being in person, although y'all live over 1,000 miles away. But I'll say to Miss Sabrina here that if you allow the child who he can't have contact with him, I can't do anything about that. But I'm guessing that Child Protective Services or whatever that is in Michigan may have a concern with that you're letting someone around him and that you're basically facilitating his violation of his bond.
I wouldn't jeopardize that.
I understand, but I don't have the jurisdiction over you to do that, but he can't have contact. So if that happens, his bond would probably be revoked, and then, whatever collateral consequences for you come out of that through DCF, Child Protective Services, whatever it is, would be outside of my control.
And, if I may specify that he cannot be within 500 feet of the child victim.
Yes.
Yes.
That doesn't change.
I believe that was originally part of the order. So
Just making sure.
all right. Thank you, Judge. We appreciate it.
Thank you.
Thank you, Your Honor.
All right.
Have a good day. What else do y'all have?
A quick bond motion, Your Honor.
Go ahead. On who?
Miss Yvonne Brenson, Your Honor, 25 CF 2125. She had private counsel previously, Your Honor. They've since withdrawn.
That was just Monday, right?
Yes, Your Honor.
Feels like a month ago already. And this is about the
GPS monitor.
GPS monitor.
Yes, Your Honor.
25 CF 2125, State of Florida versus Ivana Brinson. She's present with new counsel, Mr. Maddox.
Yes, Your Honor.
All right.
We rely heavily on the motion, Your Honor. Has the court had the benefit of reviewing it? I have a copy for the court.
I know I have at some point. It just hasn't been.
Been a while. Yes, Your Honor.
All right. And the issue is just about the GPS monitor.
Yes, Your Honor.
Is basically cost or just because of work
No, Your Honor, yeah, it's work purposes. It's causing a hardship because she lost her job as a result of the ankle monitor. It was discussed last time when this motion was either addressed or the court was asking what the contents of it would be. But one of the main hardships is that she's lost her job as a result of it, and it's preventing further employment, Your Honor. She does have some ties to the region of Florida. Recently, actually today while I was in court, Your Honor, if I may approach, I did get a statement from her pretrial services officer. I'll show the state as well. I'll show statement from her pretrial services officer. Okay. And it indicates that she's been completely compliant, Your Honor, that they have no objection to GPS monitoring.
Christina Croft. Okay,
Yes,
that's really good.
from her pretrial services officer.
All right.
So based on all of the circumstances, Your Honor, we'd ask that the GPS monitor be removed. That's the only thing we're seeking today.
All right, state's position.
The state would object. The victim has been notified, and the state is objecting on behalf of the victim. Also, the defendant lives out of state. And the fact that a firearm was pointed at the victim and time. For those reasons, the state would object to modification.
Based on the fact that Ms. Brinson has showed up for every court date that she's had up to this point, I don't think she's a flight risk. I know she lives out of state, but obviously, you know, Ms. Brinson, if you miss a court date, a warrant would be put out for you, and they'll extradite you from Georgia, which sometimes takes weeks that you sit in jail if that were to happen. I'm not trying to be threatening. I'm just trying to make sure you understand how that works. So based on that, I'll go ahead and grant the modification based on the fact that there hasn't been a problem up to this point as confirmed by your pretrial supervision officer.
Thank you, Your Honor.
All right,
All right, great. I guess that'll be removed just whenever pretrial services can get her in to do it.
I mean, they're on the second floor.
Okay.
It's only 4 o'clock. You might want to see if you can get a copy of the minute sheets really quickly.
Hold on, I'll get you a copy of the court's order.
She's going to make a copy, and then she'll give it to you.
Okay.
All right.
April 26th.
Oh, what's her next court date, Your Honor, just so we're
I'm
clear?
sorry.
I apologize, I should have asked.
I don't think we talked about that, did we?
Good asking on that.
April 27th, 1 p.m.
Make an appointment with me, okay? May I be excused, Your Honor?
Yes, sir.
Thank you.
All right, Ms. Rivers, do you have something?
Motion to modify pretrial release conditions. Cameron Reynolds. That would be 25 CF 1494.
Can I get the case number again?
25 CF 1494.